Call the Special Magistrate Code Enforcement meeting of the City of St. Pete Beach to order on Monday, April 13th, 2026 at 10 a.m. My name is Erica Augello, and I am the appointed Special Magistrate to hear today's cases. I am a practicing attorney licensed by the Florida Bar and board certified in city, county, and local government law. I have been appointed to this position in accordance with the authorities set forth in Chapter 162 Florida statutes and the City of St. Pete Beach Code of Ordinances. I'm not an employee of the City of St. Pete Beach, and I do not represent the city here today. I do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters as presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order in which they appear on the agenda unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comments related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, since the city has the burden of proof, the city will present its case first, and the respondent will then be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will make every effort to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and all parties will be provided with a copy, so please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and, under some circumstances, to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine, and a lien may be recorded on your property if the violation is not corrected by the compliance deadline, if one is provided. If you wish to present any evidence today, please sign in at the podium before you speak, and it will be necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in any witnesses. Anyone wishing to speak today, please rise and raise your right hand to be sworn in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Yes.
So sworn. Are there any changes to the agenda this morning?
Yes, Madam Special Magistrate Pete Doerr, Code Enforcement Manager for the City of St. Pete Beach. Case number 5A. Repeat violations on the third page. 2026-0047. Requesting a continuance to May.
I have that as the May 11th hearing. So that will be continued to May 11th at 10 a.m.
Yes.
Does the property owner here, or have you had any communication with the property owner on that one?
Magistrate, Senior Code Enforcement. He sent me an email. He's sick. He has COVID. Okay. So he said he wasn't going to be able to make it.
Okay, perfect. We'll go ahead and continue that until May 11th to at 10 a.m.
Yes, and the repeat violation 5B, 2026-0166. Mr. Myers, who is in attendance, is visually impaired and would like the case heard earlier rather than later, maybe the first case.
Okay.
If everyone is agreeable to that, so he can get out of here, the lights affect his.
Absolutely, we can certainly move Mr. Myers to the first case we're hearing today. Any other changes to the agenda?
No, ma'am, thank you.
Okay.
3A.
Which one? 3A.
No, okay, sorry.
No worries. Okay, so with the first change to the agenda, I will hear agenda item 5B first, which is case number 2026-0166, City of St. Pete Beach versus Jeffrey Myers.
Bear with me, please. I've got to advance the PowerPoint. Is there a quick way to do?
close, Ayako, so close.
Oh, how do you do this? Do you just click on it? Does anybody know how to do this? How do I move around? How to get to this?
Here it is. 120,
129.
122.
Nope.
122. Here we go. Thank you, Stephen.
All right, apologies, Special Magistrate. Good morning. Ayaka Rakhtashel, representing the City of St. Pete Beach. This is case number 2026066. The respondent is Jeffrey Myers. The violation address is 191 73rd Avenue. Violation description: the property is a repeat violations of sections 46-33 enumeration 12 and 13, section 9865 unsightly conditions 2, 3, 4, and 6, section 9866 residential and commercial property maintenance of the Code of Ordinance of the City of St. Pete Beach. Case summary: the initial inspection was on March 23rd, 2026. Notice of repeat violation was dated and mailed certified on March 30th of 26. Notice of nuisance dated and mailed certified on the same day, March 30th, 2026. And the notice of hearing dated and posted on the property March 30th, 2026. This is the true and accurate description of what I've witnessed. This is the affidavit of posting at the property address 191 73rd Avenue. As you are well aware, this is a property that has continuously had a lot of debris, outdoor storage. These pictures demonstrate that, once again, all the storage items in the garage have made their way out onto the driveway and are permanently out there on a daily basis. They have a dumpster on site as well that is full. They have a trailer in the front yard with a golf cart that was installed in it. Lots of items up on the second storage balcony. There's the boat's trailer with the golf cart on it. There's the items up on the second level. Their secondary driveway next to the dumpster. All the furniture and equipment is out on the driveway. Another date on March 30th here. Again, you can see all the boxes and everything, and the items just left out on the driveway. Clothes visible, and in the next shot I think you will also see the dumpster overflowing and more debris. So the problem with this property is the continual movement of items in the garage that make their way out on the driveway, back in, out and back in again. The property repeats code violations per your final order 2021-0494 on January 12th of 22. Also number 2023-0539 on January 11th of 2024, and the last one that we had on number 2024-0504 on July 17th of 2025. This is a pattern of chronic nuisance activity. It persists, and no written action plan has been received However, I must update you that on Friday, I did receive some form of a action plan. It's more of an ADA request from Mr. Myers. The city wishes to abate the chronic nuisance again. The recommended fine is $500 per day from the date of your order, because this is a repeat violation, plus $330 in administrative costs. Additionally, the actual cost of abatement services will be billed to the property owner, plus any recording fees that may be associated with this case. I would like to submit to you his request for...
Well, is it a request for accommodation, or is it an action plan under the abatement statute, or in the abatement code?
It's a mixture of both, because it says it's a request for accommodation, and he needs more time to address the cleanup effort.
Okay, so this is a request for accommodation, and that's not before me today, so I'm not going to entertain that into any evidence here today.
Okay.
But thank you. I do have a couple of questions. This is being brought forth as a repeat violation. However, there is still an active chronic nuisance abatement order on the property, and I have jurisdiction until July of 2026.
Right.
You said the city has already gone in and abated the property?
No, it has not. We've
Okay.
just bringing it back forward to you as a repeat and asking for permission if we were to need to abate it again.
So I guess my question is why? My order gave the city permission to abate the property within 14 days of the date of the order, and all you had to do was give 48 hours notice to the property owner.
I need to update, what's the status of data?
So this morning, we went over to check the property, and they have cleaned up again, as they did last time. Overhead, please. Yeah, so they have tidied up the yard. All the boxes are removed from the balcony. It's reasonable. And all the shoes removed from the second storage. So, as far as trying to abate this property for the second time, they have come into compliance again. However, this is a continuing problem, like I said, of the volume going in and out, in and out, in and out.
Which is why there's a chronic nuisance abatement order on the property, which is valid for 1 year.
Year.
So, again, my question is, so the property is now in compliance?
As of this morning,
As of
yes.
This morning,
Mhm.
okay. Anything further from the city?
Yes. The city is requesting an imposition of fines. From what date, please, Ayako?
On the first day of the pictures, which was March 23rd. Pictures there. Have to go back. No.
Slide number what?
122.
Property.
How do I get?
Slide number 122.
Well, I don't know how you get that.
Looks like the initial inspection was March 23rd to 2026.
So from March 23rd until this morning.
Anything further from the city?
That's our request, and Mr. Myers is here, and he would like to say something.
Absolutely. Mr. Myers, if you
March
need assistance or whatnot getting your way to the front, but if you could please come up to the podium.
Right into there, okay?
My name is Jeff Myers, 191 73rd Avenue, St. Pete Beach.
Good morning, Mr. Myers, and I know you've appeared before me before, and we've talked about your property in the past. My understanding is the last time we had a conversation, you were trying to clean up the property, you were getting people to help you out, and then you were attempting to sell the property. Was that correct?
It's still the same.
Okay, so you are still trying to keep the property clean, and you're attempting to sell the property. Is that correct?
Correct.
Okay. And so my understanding is that you have received the notice that the property was in violation of the chronic nuisance order, and then you received additional help to bring the property into compliance, correct?
Mhm.
Okay. Do you have anything else that you'd like to say today?
There's a lot of things I'd like to say. I'd like to
Specific to this case
I
in your home?
I understand. I did want to say that the current officer that's been working with me since the last time is really, she's a very good at being able to keep me in the loop and keep me informed.
Perfect.
My request was more so because I was struggling with, again, cleaning up after the last time that we were in trouble after the hurricanes. I paid people and we got everything done and taken care of, but it didn't address the problem in my first floor that had 6 feet of water in it. I still had bins in there that were full of water, and I was afraid to do anything till just recently I started doing things again, and I thought things were kind of picked up and everything. But I started to go through things. I'm trying to save some of the pottery collection I had that was in storage down there and stuff, and it becomes so quickly overwhelming for me. I can't do anything with it, and it's just I feel stuck that I can't even do anything without being in trouble again.
Okay.
So I know I have other ideas and plans. I was recently referred to ADA. They not only have other services like to help me in a situation like this, but they have volunteers. They have funds that they can help me with to be able to help me get to the place where I need to be, which is to be moved closer to where my family is. I only came here because of medical, and those reasons are my cancer's in remission and all of that. So it happened all during COVID and all that. I didn't want to have to move away from my family to begin with, but ever since then, this has been going on. It's just I've constantly been trying to keep the property cleaned up and I'm not really able to focus on getting myself together, getting the things that need to be thrown away, without throwing away some of the stuff that's worth money, some of the collections and things that are part of my family. It's just been really hard, and I tried again to do it, and we just put everything back in the garage again, and we'll wait till I can afford to have more help.
Okay.
I've been cut off of my savings and my resources and the trust that I've had most of my life, but I'm going to be connected to it hopefully again soon.
Okay. Well,
It's just, I feel terrible. I don't want my neighbors to have to look at something bad like that. I'd be upset too. I've not done anything intentionally. I'm just having a hard time adjusting to being blind. I just lost my eyesight when I purchased the home as a result of the treatments I was receiving. I can only work at nighttime because I can't be out. In the daytime, I'm pretty much 100% blind from the light. I just think that I would like to be able to have some time to be able to take stuff out and to continue getting things dried out. But I understand if I'm not able to do that. We talked about some ideas of things that I might be able to do once I have the financing in place, which is to have a container brought to the property, have everything moved from the downstairs into the container, and then they can go to another area to be sorted out and
okay.
saving what can be saved.
Okay. And so my understanding is your plan, while the property is significantly cleaned up now or substantially cleaned up now, and the city has determined that you are in compliance with the chronic nuisance order, that order is going to maintain and stay in place until July of this year.
Right.
So the idea is to get a plan in place and let the city know what that plan is so that they don't come back again with these types of violations for
Right.
you. So your plan right now is you submitted it here today. I can't suggest anything to you, but perhaps you want to submit it directly to the city with regard to your request for an accommodation. And then you are telling me that you might be getting a container, or at least you're looking into that to see about drying out some of your stuff, but your intent is still to clean up the interior of the house so that you can prepare to sell the home, correct?
Correct. Yes.
And you are working on funding to be able to do that, and you've reached out to other people for resources to move
Correct.
the property forward.
Correct.
Okay. All right, anything else you need for me to know with regard to this case before I move on and make my ruling here today?
Just that I think that the code enforcement officer that's been working with me has made a huge improvement with my being able to know what's going on. The last time that the fines were happening, I didn't even know that I was being fined. I hadn't heard from anybody in over a year, and it wasn't until I started to pull stuff out of the garage again, and it became a mess, that I even knew when I came to court that those fines were there. I had trouble with my property taxes. Of course, I went from having a fairly good income to no income, and I couldn't return to work, and then it took me 5 years to get my Social Security in place. That happened the last time when I actually began getting stuff done was when I had got my Social Security approved. I had the funds, I got the dumpster, and then like a week later, I was being told to come back to court again. And I'm like, well, I'm finally cleaning it up. And I came back, and then we did that whole thing, but then we just did the same thing. We just put everything back in the garage, sealed it all up, and kept it there, and just not dealt with it. So we have to have a better plan, I know, to clean it up. I don't blame the neighbors if it's what I'm told. It's not fair to them. I just had a hard time adjusting to my eyesight and being cut off with my resources when my father died. And I wasn't able to reconnect to anything until just recently in August. My stepmother passed away, and she was kind of the barrier. So my property taxes are all paid now. I need to come forward with, I guess, some other hearing regarding the fines.
So at this point, I don't know about that. The only thing that's before me here today is
Right.
a repeat violation for the property.
Right.
And I will make a determination on that today, one way or the other, and you will get written notification, obviously. Do you have somebody that's able to help you with?
I have somebody that I've been with for a long time, but they're not able to read very well.
Okay. Okay.
But and there's the ADA, from what they've just told me a little bit, they do have those kind of services available to people. I also had services through the Lighthouse, but when I received my first denial on my Social Security, I lost those services, and I've not been able to reconnect.
Okay. Well, when I do make my order here today, I will do it verbally, so at least if you have any questions, you can ask them of me here today. I don't typically do that, but I understand your situation. And then you will also get a copy that will be mailed to you.
Right.
And so if there is somebody that can help you with that, at least you have something for record keeping.
Right.
All right. Thank you so much, Mr. Myers. I appreciate your time here today. Anything else from the city?
Seat you back down here. Yes, the city is asking for, repeat violation fines from March 23rd until yesterday, so at $500 a day. That's asking for $10,500.
Okay.
Okay, thank you.
I am going to find that there is no repeat violation. This property owner and the property is under a chronic nuisance abatement order. I find that requesting a repeat violation on something that is under my current jurisdiction for chronic abatement is improper. So I'm not going to find that there's a repeat violation. I am going to find that the property is now in compliance with the chronic nuisance abatement order. The city does have rights underneath that order. If there is anything else that needs to be done, I do retain jurisdiction until July 2026. It sounds like Mr. Myers does have a plan. I understand that that's not a written plan. That's what my order required, was a written plan of action. That's what the ordinance requires. I'm going to ask Mr. Myers if he has the ability to have someone help him write that plan down for the city so that everyone knows what's going on in the event that the property runs into not disrepair, but accumulation again. I understand Mr. Myers is using his garage as storage at this point. He's airing out the items and he's trying to filter through them so that he can get the property ready to sell. The point of the special magistrate process is to garner compliance. He's currently compliant. I've heard credible testimony here today that even if I were to assess a fine, which I'm not willing to do, he wouldn't be able to pay it. So at this point, I am going to find that there's not a repeat violation. The city can continue underneath the chronic nuisance abatement order and any rights that it has underneath that. And Mr. Myers, I'm just going to ask that underneath that chronic nuisance abatement order that's already been issued, please do your best. I'm going to ask within 15 days. I will amend that order. It can be re-recorded, but within 15 days, if you can please get a written plan to the city about what you plan, how you plan on keeping the property in the state that it's currently in. And I will get you a copy of that order, of course. And it'll be 15 days from the date of my order to get that written plan to the city. It doesn't have to be formal, it just needs to be something in writing so that both parties understand what your plan is moving forward. And again, I lose jurisdiction underneath that abatement order in July, so let's try and make some good progress into keeping the property in its current state, and Mr. Myers trying to get moving the property forward.
Thank you.
So just so everyone knows, there will be two orders. There will be one that says I don't find a repeat violation, and then there will be one amending the chronic nuisance order, which will then be recorded as amended order.
Thank you.
Thank you, Mr. Myers. I appreciate your time today. Okay. Moving on to the top of the agenda, moving to agenda item 3A, case number 20250100, City of St. Pete Beach versus Armando Quintero.
Good morning, Madam Magistrate. Steve Rivera, City of St. Pete Beach Code Enforcement. Case 20250100, us continuance. At this point, the city is asking that we just get an order to dismiss. The property is compliant. There was some issues with the permitting where it was in the wrong spot. I did talk to Mr. Quintero. I do have a fence permit. It is active, so we're just going to go ahead and ask for an order to dismiss.
Okay, so there's no finding of fact that there's a violation. The violation will be dismissed.
Yes, ma'am. I never had a chance to present,
Right.
and we just went back and forth with it, so I'm just asking for an order of dismissal.
Okay, I will go ahead and get an order for dismissal out to you and the property owner.
Thank you.
All right, moving on to 3B, case number 2025071, City of St. Pete Beach versus Dolphin Watch II.
Thank you, Madam Magistrate. Steve Rivera, City of St. Pete Beach Code Enforcement. I believe we are waiting for your determination
That's right.
based on the two letters that were sent. The city is standing fast on the $1,000 per violation. So I think the ball is kind of out of my hands at this point.
So, and correct me if I'm wrong, there's been no evidentiary submissions in this case. The last time that you all were before me, there was a motion to dismiss from Mr. Leroux. I had asked for some additional legal briefing, which I did receive. Thank you both very much, in response from the city. Those two issues, or the several issues that were briefed, were whether or not I had jurisdiction to hear the challenge as far as the constitutionality of the ordinance. Mr. Leroux's arguments are well taken, so are Ms. Superich's. I do find that while I don't specifically have jurisdiction to make the determination whether or not it is an unconstitutional ordinance, those arguments will be preserved for appeal. With that being said, the arguments are, and I do have some additional questions based on the briefing, the arguments seem to be twofold, and the city's briefing brought up that the motion to dismiss kind of alleged two things. While it was an as-applied challenge to the ordinance, the basis for the as-applied challenge had to do with the notice requirement for the original ordinance, which would have been the 2004 ordinance. Is that correct?
Your memory's impeccable, yes.
Okay. Don't give me too much credit. I reread the briefings yesterday. So with that being said, Ms. Stuperich had brought up that in fact then would be a facial challenge, which is otherwise barred by the statute of limitations. I find that to be a very credible argument. Do you have any retort to that?
Well, I think that what we raised was that if there's some kind of an adoption flaw, if you were originally entitled to notice, then when you ultimately become the target of the enforcement of an ordinance that has not been adopted properly, you can raise those same arguments as an as-applied argument. That the ordinance used against you, when it is used against you, if it was never adopted properly, you then could make an as-applied argument in that respect.
Okay. Understood. And then the second argument that we heard was the inadmissible hearsay. I do find that Ms. Superich's arguments as to the fact that we haven't heard any substantiating evidence in addition to just the fact that the packet is the packet. So I'll reserve my ruling on the admissibility of the reviews until such time as any other evidence is taken and submitted to to consider your inadmissible hearsay argument and the city's response. As far as my jurisdiction, again, this is a quasi-judicial administrative proceeding. I do understand that constitutional challenges are typically brought up in this type of a scenario in order to preserve a record for appeal.
Yes.
I do not find, this is a tricky situation. I'm going to get challenged either way, I'm sure. I do find that the statute, I do understand, Mr. Leroux, your arguments with regard that you can raise almost a facial challenge on an as-applied challenge with regard to notice. When did the property owners purchase the property?
Before the ordinance was adopted.
Okay,
And
understood.
just to sort of interject, we had raised that argument previously with a number of other property owners that purchased their property after the ordinance was adopted. So we thought it was void ab initio, and in that case, it was found that if you didn't have standing and you didn't have the right to receive proper notice, if you weren't around and didn't own the property prior to the adoption of the ordinance, you couldn't raise that argument.
Right. This is different. This is
Right. And we attached the deed, I think.
at the time.
Yeah. I know there's a mistake, and I wanted to correct that for the record. In our actual briefing, we say it was purchased in 2023. We
Right.
tried to correct that. It was purchased in 2003, and we
Okay.
attached the deed to the property to show that.
I did see that. Okay, and then the other argument, as with regard to if the underlying ordinance is a void ab initio, then that would make the 2016, what you're considering an amendment to an otherwise void
Right.
ordinance, and the city is saying it is
Continuation.
continuation of the ordinance
Properly.
because
Right.
it was just a reenactment, not necessarily an
Right.
amendment to the underlying ordinance there too.
There's one other argument that we made, and that was based on the statutory preemption after.
In 2011.
Right, so the first ordinance was, for all practical purposes, in regards to that specific statute, it was not preempted. After the statute went into effect, that's when the amendment came to bring this property into the list of zoning districts that would not allow for short-term rentals, and our position was that the state statute would have preempted that and made that unavailable as an option for the city.
And it's the city's position that that wasn't an amendment to the underlying ordinance. It was a clarification to the underlying ordinance, and it didn't change the zoning distinctions within that district that would otherwise,
That is correct, Your Honor.
okay, so that the preemption doesn't apply because it wasn't, and there's substantial case law on that, well, substantial. There is case law on that, mostly out of Miami with regard to clarifying ordinances, not violating the preemption specific to 509. And do you have any response to the statute of limitations challenge with regard to the consistency with the comprehensive plan argument that the city raised in its response?
At this point, that would be the same argument, and, consistency with the comp plan, I think, would be subsumed into the requirement that that ordinance be adopted in compliance with Chapter 166. So I don't know that the comp plan actually is a consideration when it comes to those adoption requirements.
Okay, and so you find that the city's argument with regard to the one-year statute of limitations under Chapter 163 is irrelevant to your analysis because you are saying it's an as-applied challenge wherein you are raising a facial challenge within it because of actual notice
Correct.
to the property owner.
And candidly, I think that the adoption procedures, 166 is the one that has the long
Right.
list. 163 is kind of subsumed in that it's a requirement of the adoption process. So we're not arguing that it is or is not consistent with the comp plan, just that in the adoption process, that consistency was never announced on the record.
So it still goes back to the notice requirement under Chapter 166,
That is our position.
as opposed to the consistency challenge. This is not a true consistency challenge under 163, so the one-year statute of limitations wouldn't
Right.
apply.
It's, I'll just call it a checklist challenge. Nobody found it to be consistent. We're not saying it isn't consistent, but the absence of the finding goes to Chapter 166.
Okay, and then goes to the notice requirements that it wasn't properly advertised, and therefore your client did not have, the procedure to adopt the ordinance was flawed, and therefore the ordinance is void ab initio.
That's correct.
Okay. Does the city have any additional response to that based on anything that was brought up from Mr. Leroux today?
No, the city, basically, we've set forth our arguments in our response that was filed. The absence of the finding, we don't find that that constitutes a procedural flaw, and we just disagree with his arguments.
Okay. For purposes of today's hearing, I am going to find that the, if there is an argument to be made, I do not believe that I believe that the statute of limitations 5-year argument applies to the notice requirement for for the ordinance 2004-11, I believe it was, or 2004-18. And while I understand Mr. LaRoe's argument that they're seeking to use that as an as-applied challenge, I do agree with the city in that the procedural challenge is not enough to void the ordinance as it so stands.
Right.
So now you have a ruling. And I appreciate the briefing on both. It was very well done on both sides. So with that being said, I do want to hear the city's presentation and your rebuttal from Mr. LaRoe, and then I can rule on the admissibility of the hearsay evidence that you are challenging.
Very good.
Thank you, Mr. LaRoe. All right, the city would like to make its presentation.
So this case was presented already. This was, I presented this case the last hearing I believe we were at.
Did you
for
get through the full presentation?
I did.
Okay.
It was for the short-term rental.
The
There was
three,
three
okay.
reviews that were in violation.
Okay. In that case, does the city have any additional information that would like to submit, any additional testimony in support of its case?
No, ma'am.
Okay. And you did submit the Airbnb policy last time?
I did.
Okay. And that, in conjunction with the reviews, is what is giving you the ability to say that this is used as a short-term?
Yes, ma'am. I believe the Airbnb policy states that the reviews are supposed to be left within 2 weeks of the stay. Based on the dates that the reviews were left, would put them all, at least 3 of them, in violation, that we can pretty solidly say so.
Okay. And also, in addition to that, the Airbnb policy, does it also discuss who has the capability to leave the reviews?
Off the top of my head,
Do you have a copy of that with you here today?
not with me. We can grab it.
I think yes, I would like to see that.
And I apologize. I didn't know it was going to come back into question for the.
The only reason is because it's coming back on the question because of the city's argument with regard to the briefing. So
Okay.
my understanding was that the city was going to present additional evidence to combat the legal argument that Mr. LaRoe
Yes,
had
ma'am.
made. Is there anything from the city on that?
Your Honor, our briefing basically was that hearsay is admissible because it is a quasi-judicial hearing. The weight of the evidence and in the spirit of fairness, we actually defer to the magistrate's discretion in assigning that, the credibility of that evidence which is alleged to be hearsay.
And I appreciated that in your briefing. The other part of your briefing was that the argument that was to be made was that there was additional testimony, or there could be additional testimony that would be made because there wasn't an evidentiary.
That, Your Honor, that was in the event that you chose to rule in favor of the motion to deny, or to dismiss, I'm sorry.
So
So that-
insufficient or inadmissible evidence is not a proper basis to dismiss. Understood that. But then you went into the,
We just wanted the opportunity to present the evidence to you,
okay,
and that is the extent of our evidence at this time.
okay. All right, and you do
Madam
have a copy
Magistrate,
of the
If we
policy?
can get the overhead, please. I believe it's right here in the top. Host and guest can leave reviews for stays that have been booked and paid for. And then the next line down, it shows the 14-day stay after 14 days.
Anywhere in that, does it define who a guest is? My understanding from having seen this before, it's not a guest of the person renting the property. It's the guest is the person
Yeah,
renting the
and
property.
that's what I'm understanding. Host and guests can leave reviews for stuff that was paid for stays that were paid, I would assume would be,
The Is there anything else within that policy that might?
And that's what I'm looking at here for you.
And the reason I ask is part of Mr. LaRoe's argument was we don't know who's leaving the reviews, if there are multiple reviews being left on a single property.
And I'm not seeing anything in the bullet points as far as, I mean, the first, there is a first line here. Sorry, is this the right one? Yep. The first line here where it says, same thing, host and guests. Where's that other one?
Okay, so under finding reviews, it says once you're signed into your Airbnb account, you'll be able to find both reviews written about you and by you on your public profile. If a reservation has more than one confirmed guest, the host review will appear on the profiles of all other confirmed guests. So it does have to be a confirmed guest, so that's the person that they are in privity of contract with. Okay, thank you. Okay, Mr. LaRoe, any additional evidence you'd like to, or argument that you'd like to present?
I don't have any additional evidence, and obviously I completely agree with the fact that as a quasi-judicial tribunal, hearsay is admissible, but I think the case that I relied on more than anything was on page 10 of our supplemental brief, and it was, hearsay evidence may be used for the purposes of supplementing or explaining other evidence in administrative proceedings, but shall not be sufficient in itself to support a finding unless it would be admissible over the objection in civil action. So that takes it up a notch relative to formality. And it's still our position that any of these responses from a guest or whoever filled this in, that it's still hearsay. And if that's all that the city has, then they don't quite get above that threshold. Even though hearsay is admissible, it can't be the only evidence that the city uses. And from our perspective, that is all that the city has, is hearsay evidence from the Airbnb site.
Okay.
Nobody to authenticate that. And I think I'm pleased, Mr. Rivera put the regulations for Airbnb into the record, so I appreciate that. But that was basically our position.
And is your client here? Can I inquire of your client?
I do not, my client is not here today,
Okay.
so.
Because that would clear it up, right? If they could definitively say they did not rent the property on a short-term basis, that would certainly clear up your client's liability in this
It
scenario.
would, since this was primarily an evidentiary challenge to the city's evidence, and not our burden, so to speak,
Understood.
you know, we were just taking that approach.
Okay, and I can understand that. All right, thank you, Mr. LaRoe. I
Thank
appreciate
you
your
for
time.
the privilege. And thank you for the time and consideration. I know that this has probably been more extensive than anything, and I appreciate my colleague putting in all the extra work to put this in a procedural fashion where you've got more than enough to consider.
I'll say this isn't the first time. It probably won't be the last, so I
Probably.
appreciate it, but thank you.
My privilege.
Okay, I will say that this is a quasi-judicial hearing. The burden of proof is competent, substantial evidence. I do find that the evidence that the city presented does meet that standard. I do find that in the, even within Mr. LaRoe's briefing, in the supplemental briefing that says that the court, where he's citing, it says the court found that while quasi-judicial proceedings are not controlled by strict rules of evidence and procedure, they must adhere to the standards of basic fairness in order to afford due process. I do believe due process was afforded in this scenario. Obviously, notice and an opportunity to be heard has been afforded to the property owner. The property owner, understanding Ms. LaRoe said he's not here, a representative of the property owner is not here today. The property owner has had a chance to come and put forth evidence and testimony. Based on everything that I've heard here today, I do find that the property is in violation of the city's code. I do find that these violations are, and Mr. LaRoe, you didn't have any argument as to irreparable or irreversible, correct?
I'm sorry, I didn't hear you?
You did not have any rebuttal as to the nature of irreparable or irreversible of the violations, correct?
I think that's the city's position on this. I mean, it obviously can be repaired and reversed instantaneously, so.
And how so? If the rentals have already been made, money's already exchanged hands, and the guests have already left, how could it not be irreparable or irreversible?
Well, our position was which three? I guess there are 6, and we don't know the actual income or duration of any of those 6. randomly, if the limitation is 3, then 3 were circled, but we don't know which ones those were or how to quantify that. And I would think that there would be some level of, I'll say, unbridled discretion in picking 3 just randomly. That would be the evidence of irreparable or irreversible, that requirement.
Okay. Thank you, Mr. LaRoe. And while I can appreciate the argument, I do find that because there are dates on the individual reviews, that they are in chronological order. The city, and I understand, picked randomly for a 1-year period, understood. Of the 6 that are there, 3 of them clearly are indicated that they're short-term rentals and that they are permissible. 3 of them are short-term rentals based on time and abutting reviews, and so those are impermissible under the city's code. So I do find that they are irreparable or irreversible, and the city is asking for $1,000 for each one.
1,000 per violation, right?
Okay. I do not have any evidence as to how much each of those, Mr. Rivera, do you recall what the average rental on each of those was?
I do not off the top of my head, no ma'am.
Okay. I don't have any idea as to how much was collected on each of those rentals to equitably balance what that would be. In those cases, I typically go ahead and cut that in half, so I will say $500 for each of the 3 rentals, for a total of $1,500 for that fine, plus the reasonable administrative costs of the city. Okay.
Thank you, ma'am.
And I will get that order in writing, with all of my other findings in it as well, and get that to the parties. That one might take me a little bit longer, so I would expect a couple days on that one.
Thank you.
Okay, moving on to item 3C, case number 202400563, City of St. Pete Beach versus Dolphin Watch III LLC.
Good morning, Special Magistrate. Lucy Knight, Code Enforcement Officer. This is a continued case for the mini splits. Where? Can you turn? 471st Avenue, violation, the property is in violation of 98-123.1, where permits were required. They applied for after-the-fact permit. We're asking for $250 a day until the permit is open, plus the $330 for admin fees. This is case 202400563.
From which date are you asking?
Let me go to it. From the date that she requests for it.
I'm sorry?
What the date called, boss? Sorry. The date you
Date
make
of
your
the
final
order?
judgment. Yeah.
Okay. And I apologize, it's been some time. I've had a lot of other things come up, like Dolphin Watch 2. So, can you explain to me, they had the mini splits installed without a permit.
Yes, ma'am.
The city gave them a notice of violation that they needed to get an after-the-fact permit.
Yes, ma'am. Remind
me why the substantial damage letter was put in
Why it was put in?
into evidence?
Because they was like 64%, and they changed the mini splits out without having a permit, and I think they didn't have a hurricane paper.
Okay, and I have not issued anything except for orders of continuance on this case.
Yes, that's all.
Okay. And you're telling me that the after-the-fact permit has already been applied for?
Yes,
It just
ma'am.
has not been secured?
Yes, ma'am.
Okay. Do you know how long or where in the permitting process that permit is?
No, I do not.
Okay. All right, thank you. Anything from the property owner?
Good morning.
Morning.
Again, Luke Leroux on behalf of the respondent. We have taken issue with the substantial damage notice, and I believe if I didn't enter it into evidence last time, these mini splits were purchased, and I'm trying to find my evidence here just in case I need to put a new copy on, but they were purchased before either hurricane, and they were placed in, I think I've got the invoice here, they were purchased in, it looks like, I'm trying to find this here, August 30th of 2024, which predates either hurricane by weeks and or at least a month. The first one was September 24th. The next one was Milton on, first one obviously Helene, September 24th, 2024. Milton, October 9th, 2024. And the invoice is from August of 2024. The application for a permit was submitted back in January, but because of this confusion over the substantial damage issue, the permit hasn't been issued. And I think we've provided all of the evidence, the photographs, everything we could in response to the substantial damage, but the substantial damage issue just does not implicate itself in this particular matter. The permits have been applied for. It's for work that was done and items that were purchased before the hurricane. So we just like to get our permits and finish this up without going into that, I'll say, bureaucratic challenge of the substantial damage issues, because it just predates those things.
So it predates the purchase, but it doesn't predate the installation, is that correct?
I believe the installation was already done before then.
Okay,
Yes,
but without a permit.
without a permit.
Okay.
And in speaking for my client, apparently the mini splits, you just plug them in. You put them in your window, you plug them in, and they go. And apparently there was no belief that that minimal adjustment would need a permit. Apparently the city thinks it does. My client certainly agreed that if that's the city's position, we'd be happy to apply for the permit, and they did back in January.
Okay, and so the mini splits were installed prior to the two storms. So the issue, the holdup with getting the after-the-fact permit at this point is whether or not it exceeds the substantial damage determination. Your
Correct.
client's position is it's irrelevant because this was done prior to the storm, so this would have been,
That's
if
correct.
it was properly permitted, it'd been a non-issue.
It would be a non-issue. It's just the non-permitting. It's not a substantial damage issue that we'd
Okay,
like to
but that's,
overcome
and
that.
is that your understanding of why the city has yet to issue the permits?
That's exactly what we've been told.
Okay, and I see that Mr. Curtis is here. Do you have any information that you could share with us on the status of this?
Good morning, Luke Curtis, building official for the city of St. Pete Beach. So, bear with me just a moment. The question was asked about the status of the permit. I'm just trying to pull it up real quick here. Okay, so the after-the-fact permit for the mini splits, and for the record, mini splits are not plug-in appliances. They are fully required to have permits applied for and approved prior to installation. That permit is in a status of additional documentation. So the permit techs didn't even send the permit into review because they were lacking documentation. And I'm getting to those comments. Okay, so it looks like they were requesting, there are some documents that were requested, but, sorry, I'm
No, you're
just trying
fine.
to get up to speed with this one.
I kind of put you on the spot, so sorry about that.
No, it's all good, it's all good. So, the initial request was for a specific document, an AHRI certificate for the equipment. That was received on, so the permit application came in on January 9th, 2026. And then the requested documentation came in on March 5th of 2026. And then I think it looks like the The only other thing that was notated here is that because we didn't have an appeal or an approved appeal of the SISD, I'm sorry, substantial damage, substantial improvement, that it was being held for that. So for that determination, the, pulling up the other permit here that we used to track the damages. Sorry, my computer's slow. Okay. Yeah, so, and keep in mind, we have an estimate on the suspected damages. It's just that. And unless we get, unless we get complete photos or proof showing that it was not damaged, then we don't know. And sometimes what that looks like is property owner allowing us inside the house to look to see that there was no work done, or if they have, if they're just arguing the fact that it was less damage, then we can receive a quote from a contractor. We did receive 2 photos, but it didn't prove anything. It was just a couple photos of the outside of the structure, and that's it.
Does it make a difference that this is for an after-the-fact permit for equipment that was installed prior to either of the storms and would not have impacted an SDSI? An SDSI determination would not have necessarily needed to have been made prior to these storms occurring?
So technically speaking, if that was in fact installed prior to the storms and a permit was pulled and it was inspected and everything was good, that permit would have been closed. It would not have counted towards them. How the regulations work is we look at damages and improvements that are done. So because there was no permits applied for, even if they had applied for a permit and that permit was still open, it would be counted towards that substantial damage, substantial improvement determination. But because it has been applied for, we've got to look at all the numbers and to make sure that it's complying with the substantial damage, substantial improvement regulations.
Do you have a timeline of when that would be completed if they were to get you your appeal or determination or necessary documents?
So
Say they turned them all in today and it was sufficient. Do you have any idea how long it would take to run that review and say, okay, you're good with your after-the-fact permit?
I could potentially, well, with my schedule today, probably not today,
Sure.
but within a matter of days, not weeks,
Okay.
but within a matter of days, I could make that determination.
Okay. And do you know how long the SDSI appeal process is running?
Right, we're
I know.
doing it as they come in.
Okay.
So, I mean, some of them might not be immediate, but yeah, they're being addressed right away.
Okay. Okay. Thank you, Mr. Curtis. I appreciate it. Mr. Luro, do you have any questions for Mr. Curtis while he's here?
Yes, I do, if I may. I know that when we looked at this, when we first got the notice about the substantial damage, we looked at that, and obviously, just the timing of this was really what created the issue. I mean, the August purchase and installation, then the September and October hurricanes. The city was out doing its job and doing all the inspections that it needed. I can understand how this fell within the cracks, so to speak, or was overlooked or whatever. But long story short, the appeal process and everything else, to go through that, you have to hire a number of professionals, and it looked financially daunting to the property owner because you need all kinds of people that you'd have to pay a lot of money to. If we can get an agreement that all we have to do is maybe get an affidavit from the people that put it in, or some photographs from that period of time. I think that we did try to send in a few. There aren't a lot of photographs from that point. There was not a lot of substantial damage after the fact, and it certainly had nothing to do with this permitting process. But I'm just trying to limit the expenses to my client as much as I can.
Understood.
So that we don't need any additional professional architects or contractors or people like that. If we can just, provide the evidence to address the concerns the city has, I would be much relieved, and I'm sure my client would be much relieved.
Okay. Okay, I do not have the ability to control that SDSI appeal process or make any determinations on that front. The only thing I am here to look at to see is if there is a violation and give a time frame to cure the violation. Clearly, there is a violation. Those were installed prior to obtaining a permit. I'm trying to figure out how long is acceptable to give your client time to go through whatever the processes are with the city. If you and the city want to talk and to see if there's some sort of alternative process or what relief is available to your client in order to get that after the fact permit, obviously you can do that. I can't control that.
Understood.
And nobody wants me to control that, so that's good.
Understood.
So I am going to find that there is a violation of the stated code section. I am going to require that your client secure an after-the-fact permit in order to come into compliance. I am going to give, what is today, the 13th? 45 days from the date of my order, which will put us at the May or the June hearing. For compliance. The reason I'm giving 45 days is because it's unclear if you can work it out with the city. It's unclear if you're going to have to go through the appeal process, and it's unclear what that's going to look like for you. If I give you 30 days, then we'll still be in the June hearing, so I'll give you an extra 15, and good, as there's been good faith argument here today. So 45 days from the date of my order, we will be back on June 8th for a status hearing to determine what the status of the property is.
Very good. Thank you very much for the privilege, and I appreciate it to my colleagues. Thank you very much, and we'll see you next time.
Thank you, Mr. Leroux. Okay, moving on to case 3D, case number 2025-0220, City of St. Pete Beach versus Mr. Starkis.
Good morning, Madam Magistrate, Steve Rivera, City of St. Pete Beach Code Enforcement. This is a status hearing for 1104 Passag Row Way to determine fines, assess any fines if need be. As of right now, there's been no changes to the property itself. I know that the property was split, so you did sell a portion of the property off. But because there's no change, the city is seeking to begin fines at $250 a day starting today. I know Mr. Starkis is here, so maybe he can speak on what's going on with the property.
Okay. Mr. Starkis? I know the last time we spoke that you said that there was going to be a contract for sale. You were looking towards the end of March.
Yes, ma'am, that's right. And everything is in the situation that we have property on the contract, and buyers, they are dealing with the lender to get final approval. And we already said the day of closing, June 1st.
Okay.
And buyers also here to you know, if we need to prove them that they are serious and they are finalizing that
I trust
all
your
that transaction and
yeah, I trust your
so
credibility.
that's where I am in
Mr.
the moment,
Starkis.
and
I appreciate that. Okay, so everything kind of moved on as planned. You were thinking the end of March you would have a contract in place and a closing date. You do have a closing date of June 1st.
yes, we have
Just
set
waiting
up now.
on final approval of funds in order to sell the property.
Yes, that's right.
Okay.
Right.
Mr. Starkis, you want to, if you got the overhead, she can see that.
Yes, and there is.
Right there, that covers.
Oh, like that? Oh, okay.
Okay, and can you flip it around so I can see if it's an executed? Okay. Okay. All right, so then at this point, I know the city is requesting fines. In my last order, I just asked that you stay in touch, and I know the property is changing hands. We're just trying to get compliance at this time. So since the closing date is June 1st, I am going to go ahead and just set a status hearing for the June 8th meeting to see if the property is closed. If it hasn't, and if there's anything else that comes up, we'll talk about that at that time. I know you're working towards it. I don't want to assess any fines on the property in any way, shape, or form in order to interfere with Mr. Starkis' ability to sell the property, especially since there's a closing date out there. So I will just go ahead and continue this until the June 8th hearing, and we will set a status conference if we need to. If we need to see you, great. If not, it's changed hands and we need to move forward in another manner, we can do that at that time.
Okay.
And good luck to you, Mr. Stark.
Thank you. Thanks.
Okay, moving on to 3E, case number 20250705, City of St. Pete Beach versus Mark Loya.
Thank you, Madam Magistrate, Steve Rivera, City of St. Pete Beach Code Enforcement. This is a status hearing to assess any fines for the property 2782 West Vena. I believe you gave them 14 days to come into compliance. I have pictures put on the overhead. So these pictures were taken March 24th. You can see that the tags are still out of date on the pickup truck. Trailer tag, same thing. Sure. Some of the weeds sprouting out across the property there. Another picture of the overgrown vegetation. And more of the overgrown. So the order was for them to have the vehicles either registered or removed, and to remove the overgrowth. Property failed to do so, so the city's asking that we start fines on March 25th until compliant.
And you're requesting $250 a day?
Yes, ma'am, plus admin.
And what are the admin costs? $325?
$330.
$330.
$330 administrative fees.
All right, thank you. Anyone here on behalf of Mark Loya, or is Mr. Loya here? Laya? Mr. Rivera, have you had any communication with the property owner?
No, ma'am. I know there was previous cases. It seems like it was a similar thing, just no response.
Okay.
So this wasn't a repeat violation or something. The previous cases, I believe, was a dock violation, if I'm not mistaken. It came a few years before I got here, but I've had no communication. I know going past the house, I see the trash can moving, but I don't know who's moving the trash can. I can't speak on.
Okay.
Yeah.
Okay, I will find that the property is in violation of the stated code section and my order. I am going to assess a fine of $250 a day beginning on March 25th until the property comes into compliance, as well as the $330 in reasonable administrative fines to the city.
Thank you.
All right, moving on to 3F, case number 20250079, City of St. Pete Beach versus Paulette Vaselak.
Thank you, Madam Magistrate, Steve Rivera, City of St. Pete Beach Code Enforcement. Status hearing for 20250079, 1706 Pasadena Way. We're requesting this to be continued to July. I did speak with Planning and Zoning. So the permits were applied for. They had to go through the historic board. The property is historic. Now there's, I guess, some back and forth with, they need a variance. They're not going to be able to get a variance or even be heard until, I believe it's June, if I'm not mistaken.
Okay.
So no sense on bringing the property owner back before the variance could be heard. So we'd like to just continue it to July. Hopefully by then we'll be able to put this to bed.
Okay. Is Ms. Bosella here? Do you have any problem with continuing this until July, Ms. Bosella?
Mr. Rivera has everything under control. I will not be able to be present, but I spoke with Brandon this morning, and he said we can do it over the phone.
Okay.
I
In July?
Yeah, I don't know if we can do the hearing over the phone.
Well, just if you need anything from me.
Okay.
Okay, well, we can figure that out at the time. But, okay, so
Yeah.
there's no objection to the continuance then? Okay, all right, thank you, Ms. Bosella. All right, I will go ahead and order the case be continued until the July 13th hearing.
Thank you.
Thank you, Ms. Bosella.
Thank you, Steve. Bye-bye.
Thank you, ma'am.
All right, moving on to 3G, case number 20250218, City of St. Pete Beach versus Robert Putnam II.
Thank you, Madam Magistrate. Steve Rivera again, City of St. Pete Beach Code Enforcement. This is a status hearing to determine compliance with the property. This was the one that the back porch area had collapsed due to the storm. The real estate agent represented the property owner. I believe that they have a buyer lined up. I'm not sure where they're at as far as the purchase goes. I received an email saying that they had somebody interested in the property, but I'm not sure where they're at with the status of the property.
Okay. All right, is anyone here on behalf of Mr. Putnam? Anyone here on behalf of Mr. Putnam? I don't see his agent here. And you said you talked to them and they had a buyer interested, but you don't know if there's a contract?
She sent me an email asking, where we were going with it, that they had someone lined up. I received one email from her since the last hearing. Asked me what could they do to close out the case. Unfortunately, I can't close out the case until the property is compliant.
Right.
And, you know, that was her concern.
And they've done no steps to,
There's no permit application for demo or anything like that. There was another email that came in from, I believe it was Planning and Zoning, asking what the options that they had. I guess the potential buyer emailed Planning and Zoning. But again, it doesn't give me a clear determination on what the plans are with the property.
okay.
So, I mean, at this point, I feel maybe we can start fines as of today, since there's been, you know, lack of communication and no effort moving forward.
Okay. All right, I am going to find that the property is still in violation of the stated code sections and my order. I am going, when is the city requesting the fines to start?
I would, probably today. I would say today would be a fair enough starting point. We did give them an opportunity since they were trying to sell the property. So there was nothing in the order that said they had to come in compliance by a certain date. So I would feel fair would be today, or maybe a date certain from today.
Yeah. Hold on, let me read my order one more time. Okay. Okay, I am going to find that the property is in violation of the stated code sections. I am going to assess a $250 fine per day starting today's date until the property is brought into compliance. And the reasonable administrative cost of the city, you said were $330?
$330, yes, ma'am.
Okay, and the reasonable administrative cost of the city. And I'm doing that just for purposes of the record. My order stated that the respondent needed to make every effort to communicate with the city's code enforcement department on the status of the property and to make a good faith effort to move towards compliance, which we don't have any evidence here today to support that they've done that, because we have no information from them and there's nobody here to fill us in. So $250 a day starting.
A status hearing to determine compliance and assess any fines. I didn't hear from Mr. Cezanne, however, on my own accord, I did come across, he had a permit for the sewer line.
Okay.
So he was able to obtain the permit for that. That permit was issued 4/3. And I do have photos showing so when he was here the last time, he stated that most of the stuff had already been taken care of. I was hoping to get a phone call so I can come out and it's on the property, including the front. He does have, it appears to have a tenant in there that's working on, I think they're turning it into an art studio, if I'm not mistaken. So the scaffolding and stuff that's out there is them trying to do the little touch-ups here and there, so I'm not gonna hold them for that, just what I brought into, when I presented the case. At this time, I find the property to be in compliance with the order. And we're just asking for administrative costs.
Okay. All right. Is there anyone here on behalf of Mr. Cezanne? Seeing no one. Okay, I am going to find that the property is now in
Madam
compliance.
Special Magistrate.
Yeah.
Yes.
Your Honor, unfortunately, I think there's a small typo in the final administrative order saying that today's hearing was scheduled for the 12th rather than the 13th. We'd like to bring that to your attention. If you want to continue it, we're okay with that.
Have you had any conversations with Mr. Cezanne?
Not particularly about this case. There's been, we have a group email chat about some other properties. So I do know he is in the city. I know he travels a lot. I do know he's in the city, but we haven't had any conversation about 4105 Gulf Boulevard. No, ma'am.
Okay. Yeah, well, I can understand that April 12th is a Sunday,
Yeah,
so that would be
just continue it.
kind of
to the next.
impossible to do that. I mean, the property is in compliance. I think it would, since the property is in compliance, I am not going to continue it. I think that's too much time, too much money. What I am going to do is go ahead and say the property is in compliance, and I'm not going to assess the $330 in reasonable administrative costs of the city, because then there's nothing for him to combat. unless the city has an argument against that.
No, Your Honor, it's very fair.
Okay, so I will find that the property is now in compliance, and
No.
there will be no fines or administrative costs assessed on that one. Just out of curiosity, there was this, I'm going to call it a sinkhole, the depression that was there. Has he been
So-
able to work that out with the city? I know that was not kind of,
I did see it this morning, but based on your ruling at the last hearing, because we couldn't provide an
Right.
actual answer, I didn't seem to bring it up. I kind of left it on the owner to do what they needed to do.
sounds good to me. Okay, moving on to 3I, case number 202300606, City of St. Pete Beach versus Mark Broderick and Lynn Broderick.
Thank you, Madam Magistrate. Steve Rivera again, City of St. Pete Beach Code Enforcement. It's a status hearing for the unpermitted auxiliary structure that was built behind the property. I know they were, and to my understanding, they were applying for a variance to kind of keep it. I haven't heard from, I know they had retained counsel at the time. I hadn't heard from counsel. And to also my understanding, there's a lot of incomplete documents that haven't been submitted for the auxiliary structure. The application, from what I understand, has been incomplete. So at this time, based on how much time has gone on with this case, the city is requesting that we begin fines starting today of $250 a day.
Okay. I don't see Ms. Moore here, but is there anyone here on behalf of Mr. or Mrs. Broderick?
Yes, good morning. I've also got Mr. Broderick with me as well.
Good morning,
Martha Bolton. I'm with Ms. Moore's former office. She's left the firm, and I'm the new attorney assigned to the file. I have been in communication with the city planning office with regard to the status of the variance application. Ms. Moore did submit an application, and it needed a new survey, and a new survey was done March 26th. So now we're doing a new variance application, which I expect to have submitted this week for compliance review, and in the hope of getting it on the schedule for the, or completeness review, rather, to get it on the schedule for the Board of Adjustment at their May meeting, ideally. Mr.
Are those
Broderick.
reasonable deadlines that you can meet to get it on the agenda for the May meeting, from your side of things? I understand you can't control the city.
In communication with the planning office at the end of last week, I was led to believe that that was possible, if we get it in this week. That if it doesn't make the cutoff for the May meeting, we would at least be on the June schedule.
Okay.
And we do have all the pieces for the amended variance application now.
Okay. So it is as soon as it's submitted by the remainder of this week, if it's heard at the May meeting, whether or not it's granted, it would at least be able to, okay.
Yes.
All right. Anything else that you'd like to present?
Mr. Broderick, who is here, has taken great steps to meet all of the conditions that were outlined in the communication from the planning office from January of this year, end of January. He's gotten the new survey now and has addressed the items with regard to the structure having plumbing. It no longer has plumbing. There was a wall taken out so that there's not an enclosed space that's in excess of 80 feet. There's no need for a height variance, and the only variance at this point that's going to be sought would be with regard to setback, and it's a reasonable variance request. We're optimistic about it. Mr. Broderick's pool has a retaining wall that cannot be moved, and the maximum setback would be about 17 feet, and then the requirement is 20 feet. So we're seeking a 3 feet variance there, and approximately 3 feet on the side for the same reason.
Okay. Okay. Anything else from the city?
No, ma'am, we just, I mean, if you're looking to continue it, we just ask that communication just stay strong. There's been no communication since the last hearing.
Okay. Well, and it does make sense that if Ms. Moore is no longer with their firm and she was the point of contact,
Yeah.
that that probably had a little bit to do with it.
Just state that, to make sure that we keep the communication ongoing.
Okay, yeah, okay, well,
Definitely.
I will go ahead and we will come back for a status hearing on June 8th. Hopefully it will have gone through the variance process, and then we can determine if it meets the variance, if it doesn't, what the options are after that. And I will put in the order just to please make sure that you stay in communications with the code enforcement department as well as the planning department, so they know where they are in the process.
Thank you so
And
much.
please just make sure I have your email address, since I was communicating to Ms. Moore before.
It's the same as Ms. Moore's, but it's Martha, M-A-R-T-H-A, at Coates, like multiple jackets, dash Schmidt.
Okay, perfect. Thank you so much.
Thank you.
Okay, moving on to 3J, case number 202505991, City of St. Pete Beach versus Beach House 78 LLC.
Ayaka Ruckshell, representing the City of St. Pete Beach Code Enforcement. This is a status hearing for the property at 510 79th Avenue. Your last order gave him 15 days until March 23rd to comply. I did not hear from anybody that they had cleaned up the landscape. However, I did go out this morning, and the property is compliant. Overhead, please. Apparently, that's the debris that they just trimmed off, and it will get collected. And it's no longer overgrown. So the city's not asking for any fines, just administrative costs of $330.
Okay, thank you. Anyone here on behalf of Beach House 78th LLC? Anyone here on behalf of Beach House 78th LLC? Okay, seeing no one. I will find the property is in compliance. I'm not going to assess any fines, but I will assess the $330 in reasonable administrative costs of the city.
Okay.
And moving on to new cases, 4A, case number 202600150, City of St. Pete Beach versus JSC Group LLC.
Ayaka Ruckshell, City of St. Pete Beach Code Enforcement, case number 202600150. The respondent is JSC Group. Violation address is 510 79th Avenue. Description, the property is in violations of section 98-123.1, permits required of the Code of Ordinance of the City of St. Pete Beach. The case summary, the initial inspection was on February 24th, 2026. The notice of violation dated and mail certified March 17th, 26, and the notice of hearing dated and posted on the same day of the property. Oh, not the same day, March 31st, 2026. This is a true and accurate representation of what I witnessed, the affidavit of posting on March 31st at the property address. So this sales history record here shows that the property was purchased by JSC Group back in February of 25, and it is currently listed on the market as of February 26. This is the sale listing as of February 20th, 26, showing that the new home that's for sale. A little bit of description about this home. It has luxury vinyl planking, a quartz countertop, backsplash, floating shelves, herringbone LED lighting, spa-inspired primary bathroom, garden tub, floating vanity, and a covered lanai, new HVAC, new water heater, and newer roof, impact-resistant windows. Again, home summary of the renovations that were done to this home, as illustrated previously. The property owners received a letter from the building department saying that this home was substantially damaged and that they had not applied for a hurricane repair permit. So they were asked to provide the status of the home, and they said that they received 0 damage at the property. And so we're asked to provide us with pictures of the pre-storm to show that there was no damage since then. And this is the two interior pictures that they provided. This is an illustration of the picture of the home prior to the storms. I believe this is taken back in maybe 22 is the last Google picture I could find. But you can see the door, the window in the door is different to the windows on the side as well. Compare that to, they also have an exterior lanai. This was the picture pre-storm. Pre-storm. And these are the current pictures of the new house here. So you can see that the door has changed. Also, the windows have been updated. This is the current lanai. And the backyard as well with the current lanai. This is the new interior, front door entryway. The new kitchen. New kitchen. The new lounge and dining area. The new master bathroom. The second bathroom that was added to the property. Updated bedrooms. So they had an SD determination of substantially damaged 67% of the structure value. They also received flood insurance claim money of $110,000 received for the building. There was the hurricane damage letter, as I said, sent on January 6th requesting the owner's response, and they provided us with the pre-storm pictures. This was their response. They selected option 1, that they had received no damage. So the corrective action is that the property must obtain a hurricane repair after the fact permit for both the interior and the lanai renovations made. The property is not compliant, and the recommended fine is $250 per day from the date of your order, plus $330 administrative costs and any recording fees that may be associated with this case. The city would like to ask the building official to come up and comment on this property.
Before Mr. Curtis comes up, I have a question. You've provided evidence in the PowerPoint that says that the property was sold on February 13th, 2025.
To the current owners.
To the current owners,
Yes.
correct? And then you're saying that they've done these renovations after 2025, and the storms occurred in 2024.
Correct.
When you say that they've reserved NFIP flood insurance money, who received the NFIP flood insurance money?
That's not clear, but that's to prove that there was substantial damage.
Okay, and
Whether he,
request for the permits, or you're saying that the current property owners are the ones that did the renovations in the house?
correct,
Not the private property owners?
correct.
And the listings that you've posted are for the new listing? Okay.
Correct.
Just wanted to clarify. Okay, Mr. Curtis?
So I'm also the floodplain manager for the city. So as that role, part of what we do is we receive data from NFIP. Now, NFIP is very tight with that information, so I've got to be careful how much I make public knowledge of that. But there were claims. The dollar amount is sent to us. As a matter of code enforcement, they don't have any qualms with us divulging that information. But in this instance, there was an estimated 36 inches, again, estimated 36 inches of stormwater inside the home. When NFIP pays out a claim, they're looking to the municipality to enforce the regulations. So in this case, that proper repairs were done so that somebody just doesn't abandon their home and take the money and run. So that is part of the issue. The other part is life safety. So at 36 inches, there is a significant exposure of the electrical system to the stormwater. Salt water is very corrosive. We've seen numerous fires throughout the city. This is my strongest point that I try to emphasize to property owners, contractors, that these things need to be addressed. So in this case, we want to make sure that this home is safe. So if this is being sold, that somebody doesn't inherit these issues that are potentially there.
And to your knowledge, there has been no permit that was pulled to make any of these renovations, or would a permit have needed to be pulled to make any of these renovations?
Permits would have needed to have been pulled, and I can tell you, sorry, bear with me a moment. Okay, so, here, let me just pull this up so I can see exactly what the status is. My apologies.
No worries.
Correct?
Yeah.
Okay. Okay, so I don't see any permits here. 510 79th, right? Just 510 79th Avenue. So I see permits from March of '24 and before, but no permits have been applied for any work on this structure.
And what were the March of '24 permits that were pulled?
March 24 was replacing exterior front door size for size.
That was the only one that was.
Yeah, let me just see. Yeah. Just looking to see when that was issued.
But nothing for interior renovations or windows, anything like that?
No.
Okay.
Yeah, and so for the record, that door was inspected on May 9th of '24,
Okay.
and that permit is closed.
Okay. Thank you, Mr. Crooks. Anything else, Ms. Rectorshell?
Nothing from the city, but I believe there is a representative here for the owner.
And who is here for JSC Group LLC? No, go ahead. If you could go ahead and state your name and your affiliation with JSC for the record.
Yes, ma'am. My name is Glenn Alexander. My affiliation with them is they sub me a lot of work as far as renovations, landscaping, and things of that nature. And he also gave me a power attorney on his behalf.
You do have a POA for JSC.
Yes, ma'am.
All right, if you could just submit that to the city, that way they have that.
And has Mr. Alexander been sworn?
No, yes, sir. I swore it in at the beginning.
Okay.
Yes, sir.
Okay. And Mr. Alexander, can you explain to me what happened on this property?
I have a letter from JSC that kind of explains it. You want me to read it?
Submit that, and I can, if you want to give it to me, that way I can read it.
You want me to give it to you, ma'am?
Yes, please.
Do I come up?
You can show it to the city first to make sure that they, is that something that you've seen before, Ms.
And
Rectorshell?
also I have the power, not the power attorney, but the permit, the JC application with the affidavit and the GC that's in it, because I guess what he's asking for is like an extension to get whatever need to be done, and also he has the actual general contractor information on here as well. So whatever needs to be done for the, because I guess he only got a 13-day extension, and he kind of needed a little bit more time, ma'am, to get some of the work done, some of the renovations done as well. I have all the documentation from St. That he had me print out for him.
Ms. Supers, did you want to see this at all?
Yes.
You know, if there's any objections to submitting that into evidence.
Do you want to look at it?
And also, ma'am, Attorney Amir, he also gave me pretty much a docket list of all the history from the start as well.
So I guess my question is, JSC purchased the property in February of 2025, correct, after the storms?
Yes, ma'am.
Okay, and then proceeded to do renovations without having the proper permits, is that correct?
Well, I'm just being you know,
Well, you are here to represent JSC. I know it's not, this is not your cup of tea.
Yes,
But
ma'am.
if you have the information, please let me know. If you don't have it, you can just say you don't have that information, that's okay.
no, I don't have that information. I thought what I had in front of me was pretty much everything I needed to present for you all.
Right.
Because according to when I spoke to him, it was pretty much, he's already been complying with the city of, St. Petersburg Beach, and he wanted an extension, because I guess he only got like a 13-day
So
extension.
the notice of violation was issued, and he had 13 days in order to come into compliance. Ms. Rectichel, it does say in the information that Mr. Alexander handed me that they were in contact with you, the property owner was in contact with you. Do you recall any conversations with the property owner? Oh, sorry.
Speaking there, sorry.
Oh, I'm sorry, ma'am.
This is the wrong case, but anyway. I had spoken to the property owners but their argument was that they had zero damage.
Not that they needed permits?
Yes, absolutely, they needed permits, because we were saying you did do renovations, and they were saying they didn't do renovations. So they were then asked to provide the pictures pre-storm, et cetera, and now I believe they're realize that they do have to apply for a permit. However, what was received on 3/31, I believe, was incomplete because there was no GC signature on it.
Okay.
And plus the diagram that was submitted for the property
Yes.
was incorrect because it only shows one bathroom when we know that there are two. Overhead,
Okay.
please. So it says the application has not been received.
Okay. Okay, anything else, Mr. Alexander, that you want me to know before I make my ruling on this? I know that they're just looking for an extension time. Do you have any?
Correct. I mean, I didn't know, she just, they had gave me pretty much the violation, the notice of violation, and all the, I guess, the email traffic that they had been, I guess, collaborating with.
Okay. Okay. I am going to find that the property is in violation of the stated code sections. It's very clear from the evidence and the testimony given here today that renovations were done without a permit, and that a permit is now being applied for. I am going to give 45 days
Okay.
to come into compliance, and that means to secure a permit. I don't know if that's, based on everything that we've heard, that might be reasonable. It just depends on what's submitted and what arguments are had. So 45 days from the date of my order, I will get you a copy of the order, make sure I have your email address. That will get sent to you since you have power of attorney. And I'm just gonna ask that you relay to JSC Group that whomever they send at the next hearing, which will be June 8th, that they send someone that can answer questions specific to the property. So if that's the GC or whoever was doing the renovations, while I appreciate your time here, Mr. Alexander, you don't have any more information that I need. So they need to send somebody that actually has the information. Otherwise, things are not going to necessarily be cleared up, and they will be subjected to fines.
Okay.
Madam Special Magistrate,
Yes.
before you finalize your order, could we get a status update, even an application within the next 2 weeks, a status update at the May 11th hearing? With the condition of an additional 30 days, as you mentioned, which would total 45, for them to be in compliance?
Your Honor, we would like to see some movement to actually applying for the permit within a shorter period of time, and then securing the permit, as you've mentioned, at a later point.
Okay.
Bearing in mind the property is being sold.
Understood. I think the point is compliance, right?
Yes.
A permit has been submitted, but it's not been, there's no completeness review.
Correct, the application is incomplete.
So a permit application has been submitted already. It's just not a completed application.
I was looking at Luke shake his head no.
It hasn't been accepted because it's incomplete.
But it's been submitted. It's just not, it's not in review because it's not completed.
Email, not through official.
Oh, through the portal.
Or anything like that, so.
And do we know is the GC already registered with the city?
Luke has the GC registered.
Do we know if the GC's already registered with the city?
I mean, is Mark. Can't pronounce that last name.
Here, would you like glasses?
So, Your Honor, we're just looking for an interim step.
Right, which I'm trying to figure out if it's been submitted understand through email. I'm just trying to figure out if it's going to take more time for them to register the GC and get the permit application submitted. They might need a little bit more. I'm just trying to figure out the timing on that.
I got it.
Intermediate step. So who is the GC on the?
His first name is Mark. His last name is spelled M-O-R.
Without a date, like an interim date.
Mr. Curtis, do you have any information on that?
I don't.
No? Okay. M-O-R.
I don't know if that's a I or S-S-O-T-A. I don't know what these two letters are. I can't.
Okay.
Can't.
Okay.
He got glasses on. He might be able to help me out.
Or it's written in contractor language.
Right. Doctor's handwriting.
So the name he's trying to, so we have a plumbing contractor and an electrical contractor that has signed and notarized this,
But no GC.
but it's no GC. Who is listed as the plumbing contractor has signed on as the
GC.
general contractor, which wouldn't be allowed unless he has multiple licenses, but I don't, it does list the
His GC
so
license.
It could be that he does, but just, if I may.
Oh, go ahead, sir. I'm sorry.
Just want to be able to speak into the mic so that it's clear in the recording. So for the record, a permit application has not been submitted. It is not in the permit system.
Okay.
If they emailed a permit application, that is not the appropriate, exactly. So they would need to actually apply for it, get it into the system, give us all the supporting documents, and pay the fees that are included with that.
Perfect.
And then, if I might, if I just get clarification, is the contractor that is signing off on this, is that the contractor that did the work?
I wouldn't want to answer that question because I'm not privy to that answer, sir. I just know that he wanted me to stand in the gap because I have done some landscaping work for him, and I'm licensed to do handyman things with my company, and I've done work with him in the past, and you know, he's in West Palm, so he just really wanted an extent. He wants to get these things done, so he wants just an extension to be able to take care of.
I think he has some unrealistic expectations about what was going to happen here today. So if you could just, again, just let him know whoever he sends in, well, we'll do one for May and one for June. Whoever he wants to send in May and whoever he wants to send in June needs to have concrete information. He can't send you if you don't have the information. He can send you, but
Right.
it's not going to work to his favor.
Understood, ma'am.
Okay.
Totally understood.
Okay, so I am going to find that the property is in violation of the stated code sections. I am going to allow for 7 days from the date of my order to apply for the permit. Just an application through the proper channels. We are going to meet back here for a status conference in May to determine whether or not the application has been submitted. The second part of my order is that after the application, they're going to secure a permit within 45 days of my order, and then we are going to be back here in June as a 2-step process to figure out if that permit has been secured. So 2 steps, 7 days to apply, 45 days to secure the permit. And we will have a status conference on May 11th.
Would I get that in an email, ma'am? I'm sorry.
I'm going to send an order that will have all that information. If I have your email address on the sign-in sheet, you will get a copy of that. I'm also going to just mail it to the JSC group also because I think they need to understand what's kind of happening. And then at the June 8th hearing, we will make a determination as to whether fines should be imposed.
Thank you.
Yes, ma'am.
Okay. Thank you, Mr. Alexander. I appreciate your time today.
Thank you, ma'am, for allowing me.
Okay, moving on to 4B, case number 2026-0058, City of St. Pete Beach versus, I'm so sorry, Rimvidas and Ruda Balkas.
Ayaka Rakdashel, representing City of St. Pete Beach Code Enforcement. This is case number 2026-0058. The respondent is Rimvidas and Ruda Balkas. Violation address 8380 Gulf Boulevard. Violation description, the property is in violations of sections 46-33 enumeration 1B, 12, 13, Section 98-66 residential and commercial property maintenance, A and B, 22A, B2, and Section 22.12 tree removal permit required of the Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspection was February 4th, 2026. A courtesy notice was dated and mailed certified February 5th, 2026. The notice of violation dated and mailed certified on March 9th, 2026, and a notice of hearing dated and posted on the property March 31st, 2026. This is a true and accurate description of what I witnessed. This is the affidavit of posting on March 31st at the property address 8380 Gulf Boulevard. In the picture, you'll see a large, it's dead tree in the front yard from a few angles. This is also the unregistered trailer that was on the property, March 5th. Taken from all angles, showing that there is no registration plate at all to the trailer. March 19th, the tree was still present. So the corrective action, the property must remove the dead tree after obtaining a permit and register the trailer to remain on site, or it must be relocated. The property is actually now compliant, so we're not asking for any fines, just $330 in administrative costs. The tree was cut down by the owner. The trailer was actually owned by somebody else, and they were just parking their trailer at the property. So that took a little bit longer to get that moved, but that, as of last Thursday, they moved the trailer. So it is now compliant.
Okay. Perfect. All right. Anyone here on behalf of the property owner? If you'll come up, state your name, and if you have anything to say, please let me know.
My name is Remidas Balkus, and what else did you need to know?
Nothing unless you have anything that you want to tell me. It sounds like the property is in compliance now.
Yes, I'm just sorry it took that long to cut down the tree.
Oh, I appreciate that you came into compliance. Makes my job easier.
Oh, no.
So no fines then are going to be assessed, but the city is asking for $330 in administrative costs.
Okay.
Do you have any response to that, or are you okay?
Oh,
with
of course, I'd prefer not to.
Yes.
Or if I could pay half of it, no, I understand, Your Honor. I understand completely.
Well, thank you so much, Mr. Balkus. Okay, anything else from the city?
No, ma'am.
Okay, I will find that the property is in violation of the stated code sections. The property, however, is now in compliance. I'm not going to assess any fines, but I am going to assess the $330 in reasonable administrative
Okay,
costs.
thank you, Your Honor. Thank you for your
Thank you
patience.
so much, and you have a wonderful day.
Okay, thank you. Thank you, officer. Thank you.
Okay, moving on to 4C, case number 2026012, City of St. Pete Beach versus Lemke Ranch LLC.
Okay, Ayaka Rockshell, representing the City of St. Pete Beach Code Enforcement. Case 0202601112. The respondent is Lemke Ranch LLC. Violation address 8840 Gulf Boulevard. Description: the property is in violations of Section 46-33, enumeration 2 and 12, Section 6.12, commercial accessory and temporary equipment, structures, portable buildings and trailers, dumpsters, and commercial tents. D5, Section 6.13, residential accessory structures. E4A, and Section 9865, unsightly conditions 4 of the Code of Ordinance of the City of St. Pete Beach. Case summary: initial inspection was February 13th, 2026. Notice of violation dated and mailed certified February 24th, 2026. And the notice of hearing was dated and posted on the property on March 31st, 26. This is a true and accurate representation of what I witnessed. The affidavit of posting on March 31st at the property address. So back on February 13th, there were multiple dumpsters and storage units on the property with building material, a sand pile, looked like, the portable storage unit. And then on March 19th, there were additional new building materials appeared. Again, additional, looks like pavers now. And the dumpster was still present. More building material, rock or sand. So this property didn't have any valid permits on the property. And when investigated, it actually had an old dock permit that had expired last year. So the owners were contacted, and they didn't realize that the permit had expired, and therefore all that building material wasn't allowed to be on the property. They then decided to form their own LLC and become their own contractor to complete the work. And initially, they wanted to open a landscaping company, I believe, but that didn't comply because this is a commercial property, had to be a GC, so they opened a GC company, and they had to get that permitted through the city, BTR, et cetera. So that caused a little bit of delay. So as of April 2nd, they have now applied as their own owner, as a company, applied for a paver permit, which is still in review. So I wanted to call Luke Curtis up to just give you the status of that permit in review.
So just to update on the status of the permit, so it was applied on 4/2/26. A review was completed on 4/7, 5 days later, and comments sent out. No response has been received on those comments. And so that the permit is still in an in-review status.
Okay. Thank you, Mr. Curtis. And Ms. Rectichel, do you happen to know, are the building materials still sitting on the site?
Yes, they are, ma'am.
Okay. Anyone here on behalf of the property owner, Lemke Ranch LLC?
Yes.
If you could please state your name and affiliation with the LLC for the record.
Chelsea Lemke, I'm the owner of the house.
Okay.
Can you hear me?
Yeah, are you the principal of the LLC?
Yes.
Can you tell me what's going on?
Yes, we're actually waiting for, I believe, sorry, my husband's been dealing with this, but he's waiting to hear from a Brandon Berry from the city. I don't know who that is, but I think he got an email on Friday from the city saying that we're waiting to hear if we're allowed to put pavers over, maybe you might be able to answer this, over a utility easement. I guess sorry, I'm trying to read his email that he just sent me. They said that we couldn't put we can't put the pavers over a utility easement, so we were waiting for Brandon to, I guess the city is telling us differing information, I'm not sure. So we did apply for the permit, which the city made this super hard. We're business, our home is in our LLC. And so we were gonna put the pavers ourselves. We didn't realize that our seawall, when we put our seawall in, we didn't realize that permit was no longer valid. So we tried to apply for a permit ourselves, was told we couldn't because our home's in our LLC, so.
It doesn't qualify for an owner.
Yeah.
That's a state statute, that's not really the city. So.
Okay, well, whoever, yeah, which when I went, when we first got this letter in February, came here to try to get a permit, so we have been trying since February to do this, but.
Okay.
So.
And so at this point, you are saying that the Brandon Berry, which my understanding is the planning department.
Not sure, yeah.
That they're going through that process, okay.
Yeah.
Okay. Anything else that you'd like me to know?
No,
All right.
just working on it.
Appreciate Ms. Lemke.
Yeah.
Anything else from the city?
No, ma'am.
Okay. Mr. Curtis, I know you're not in the planning department, but do you have any idea, you're saying that you sent out, the comments were sent out from the building department or from the planning department on the permit?
From planning and zoning.
Okay.
They sent out the comments, and
And so those haven't been addressed yet, but it sounds like maybe there's some communication between.
correct, yeah, if you've been in touch with Brandon Berry, he's the planning department. They may be trying to work through the issues, but yeah, there were a couple comments that were sent out to address setbacks, and I'm just breezing through this, see if there's other things. Yeah, looks. Oh yeah, and then yeah, then there was a comment here about the utility easement. So Yeah, if they're in communication with planning and zoning and working on this, then that might be why we haven't received anything. But it was,
At the beginning.
it was just resulted not that long ago, on the 7th.
Okay. And the violation is not for not having a permit. The violation is for having unsightly conditions on the property with regard to the building materials. Ms. Rectichel, if the permit is secured, can those materials remain there for the duration of
If the
project?
permit is secured, yes,
If the permit is secured.
correct.
But if the permit is not secured, then they have, as it stands, it's a violation. It can't be there unless
Correct.
there's an active permit.
Correct.
You guys have been giving me some really fun ones. Thanks. Okay. All right, thank you very much. I am going to find that the property is in violation of the stated code sections. The remedy is going to be to come into compliance, whether that is to secure a permit so that you can have the construction materials on the property or to clear the construction materials from the property. From my position, it's irrelevant to me. It's however you can come into compliance. I will give you 30 days from the date of my order to come into compliance, because that might give you some time to go back and forth with the city and get a permit secured so that those materials can remain there. That being said, 30 days will put us at the June hearing, right?
Yes.
Yeah, so 30 days from the date of my order, we will come back on June 8th if necessary to have a status hearing and figure out what's going on with the property at that time. And just make sure I have your contact information. I will send you an order. It will have all that information in it. Just stay in contact with the city and you should be okay.
Thank you.
So clarification
Yes.
is, you said the June
8th.
hearing.
Because if I do 30 days from the
Property.
date of my order, 30 days from today is May 13th.
Yes, ma'am.
And it's, the next hearing is May 11th, so 30 days doesn't do us.
Correct. I was asking about the fines that you're saying that property is in violation.
The property is in violation, and I'm allowing 30 days for the property to come into compliance. So whether that's removing all the building materials from the property or securing a permit so that those building materials can be on the property for the duration of the project, doesn't matter to me. But if in 30 days those building materials are still there and there's no permit, then we can discuss fines at the June.
Very good. Thank you.
Thank you.
Thank you. Moving on to 4D, case number 20260170, City of St. Pete Beach versus Charisma Maraski.
Yes. What's happened here? 1-7, this isn't it. How did we get out of order?
It's the one right before that one. Other. It's gonna go the other way. It's the one before it.
Before?
Mm-hmm.
Gates above it.
The JDH is the one after, the one we're on. So this is Maraski.
Case ending in 170.
So it's further down.
Okay. JDH Holdings now.
Isn't it 170?
Here's my Lemke one. Doesn't appear to be there, so I may have to ask for a continuation until next special magistrate.
Okay.
170.
I mean, I have the PowerPoint in my packet, but that doesn't do us any good. Okay. All right. Is anyone here on behalf of Charisma Raski? Okay. All right, then I will go ahead and continue this hearing until the May 11th hearing date.
Okay.
Okay, moving on to 4E, case number 20260171, City of St. Pete Beach versus JDH Florida Holdings.
Ayaka Ruktashel, representing the City of St. Pete Beach Code Enforcement, case 20260171. The respondent is JDH Florida Holdings, LLC, violation address 9111 Gulf Boulevard, violation description of the properties and violations of Section 8.2A, permitted principal uses and structures of the Code of Ordinance of the City of St. Pete Beach. The case summary, initial inspection, March 30th, 26. Notice of violation dated and mailed, certified, March 31st, 26. Notice of hearing dated and posted on the property, March 31st, 26. This is a true and accurate description of what I witnessed, the affidavit of posting on March 31st at 9111 Gulf Boulevard. This is a short-term rental Airbnb posting for the property. This illustration here shows that you are able to book for a short-term 5-night reservation. This is the home as advertised on Airbnb. Entry, the pool. There were 3 reviews as of March 31st, 2026, and the screenshot was taken March 31st, 2026. You can see that one review was 1 week ago, before the end of March, then another one 2 weeks ago, stayed about a week, and another one 1 week ago also. Here are the 3 short-term rentals in March of 26. This is the Airbnb review policy that we've included. The corrective action is the property can only be rented monthly. The property is not compliant, and the recommended fine is $1,000 per violation. There's 3 reviews, plus $330 administrative costs and any recording fees that may be associated with this case.
Okay, thank you. Anyone here from JDH Florida Holdings LLC? Okay, if you could come, please state your name and your affiliation with the corporation for the record.
My name is James House. I'm the owner.
Okay, and you are the principal of the LLC?
Yes.
Okay. Can you explain to me what's going on with the property?
Guilty as charged. I just took some bad advice, was unaware, and I've just plead ignorance and willing to accept my fine. And I've taken the listing down, and now I know that it's long-term and I'll be in compliance.
Okay. And let me ask you, on those 3 rentals, do you know what your average nightly rental rate was?
To be honest with you, I don't, but I believe it was $300
For each night?
per night. Yes.
Okay. Okay. Anything else you'd like for me to know?
No, I did buy the property for, I have business partners up north. I actually live down here in the winter, and just kind of bought it for all of our families and things like that. So we were just trying to make an income when it wasn't being used, but I'll correct it and only do long-term rentals.
Okay, great. Thank you very much. I appreciate your honesty.
Thanks.
Anything else from the city?
No, ma'am.
Okay. I do find that the property is in violation of the stated code sections. I do find that all 3 rentals were in violation. I do find that they are irreparable, irreversible, and I will assess $1,000 for each rental plus the $330 in reasonable administrative costs of the city. And any recording fees, I'll build that into my order. Okay, moving on to 4F, case number 20260133, City of St. Pete Beach versus Mark Griffey and Shannon Griffey, the revocable trust of.
Thank you, Madam Magistrate. Stephen Rivera, City of St. Pete Beach Code Enforcement. Case number 20260133. Respondent is Mark and Shannon Griffey. Revocable trust, Mark S. Griffey trustee. Violation address is 2101 East Vina Del Mar Boulevard. Violation description, the property is in violation of Section 8.2, permitted uses and structures of the Land Development Code of the City of St. Pete Beach. Case summary, initial inspection was 3/3/2026. Irreparable or irreversible notice of violation dated and mailed certified 3/10/2026. Notice of hearing dated and posted on the property 3/10/2026. Following is a true and accurate representation of what I witnessed. This is the affidavit of posting at 2101 East Vina Del Mar Boulevard. This is the VRBO advertisement. Property had one review that did not meet the standard. As you can see, it says, it might be hard for you to see it or not, but it says stayed 21 nights. There was no other, the other two reviews that are on there, they were third-party reviews, so VRBO doesn't have the ability to show how many nights those were. This one clearly says 21 nights. It's the VRBO review policy. Corrective action, property can only be rented monthly. Property is, I haven't seen any more reviews, so I'm going to change this to compliant. Recommended fine is the $1,000 per violation for the one review, plus the $330 administrative costs and any recording fees that may be associated with this case. And that concludes my presentation.
Okay, anyone here on behalf of the Mark and Shannon Griffey Revocable Trust?
Yeah, right here.
Okay, if you could please come up, state your name and your affiliation with the trust for the record.
I'm Mark Griffey, the owner of the property.
Mr. Griffey, what would you like for me to know today?
Well, that property's been rented for the last 4 to 5 years, and we've had the monthly rentals, you know, which I'm aware of, and I have a rental company managing it. So I would need to find out from them what happened. I didn't know, we had no information at all. I don't know if, you know, somebody was complaining, you know, a neighbor or whatever, and so we had no evidence at all. So this is the first time I've seen that that's what the problem is. And I need to talk to my rental company to find out what the situation was.
Okay, so just so for clarity's sake, you are saying that this property, you've had it rented, but it's always been a 30-day rental?
Yes.
Or 30 or more?
Well, that's 30 or more, yes.
Okay, and then so this one review, this outlier 21 days, because you have a property management company, you're unclear as to what exactly happened?
Yes, exactly.
Okay.
That's what I'm saying.
I do find that 21 days is weird stay time, but that's neither here nor there. Okay, and so you have not, because you're of the presentation evidence, that you, when you got the notification, you didn't contact the city at all to find out what was going on?
Did we or not?
If you want me to swear, I will swear you in. Like, I was not expecting to do this today.
There we go.
Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do. Your
Okay,
Honor.
if you could come.
Nancy Southworth, and I am Mark's girlfriend. We've been together 6 years. I help him manage the property.
Okay,
So,
so if-
Shannon has passed away. His wife, he's widowed with her for 8 years now. So.
Okay. Can you tell me what happened with the rental? Do you know?
I don't know. That's what we were going to ask for a continuance, because we live in California. We don't live here. So we flew in to be here today. I thought we would receive an evidence package or something so that we could address the issues, but we didn't. The property manager wasn't aware of, when we asked them what had gone on. They aren't able to be here today, so we were thinking I don't know if you're available, if we're allowed to appear by Zoom or some other.
That's up to the city. I don't have any control.
Okay, I didn't
over
know if that was even
that.
available to us if we have to go back to California, but we could come back in May and give us the chance to investigate. We do rent it for 30 days or more. Most of the people have been coming back for 4 years, and they rent it for, last guy was there for 3 months, 2 months, 3 months. So, I mean, we don't, and this is short-term rental. We have really good relations with our neighbors, and if there's any problem, you know, or anything, they come to us. So we didn't know how this happened.
Okay.
So.
Does the city have any objection to a continuance on this to determine whether or not, the only reason, I wouldn't ordinarily even entertain the request, but it's 21 days, which seems a little odd to me.
I think it's a fair request. This wasn't a complaint-driven,
It just came through the scans.
when
for the-
doing our everyday, research, we came
Proactive.
across it. Yeah, it was a proactive opening of the case.
Okay.
So I don't, and Nancy, you don't have any objections with continuing it, do you?
No, the city's goal is really to bring people into compliance. Today, they're now aware of what's transpired.
It's just a glitch. I don't know. You know, we've
Yeah,
been
and-
doing
and-
this.
There may be-
We're aware of it.
Yeah.
There may be an actual reason why, you're right, 21 days is odd, so.
Yeah, yeah.
Maybe it could be a glitch. I mean, I have no issues with continuing it.
Okay. Then I will not make a ruling here today. I'm going to continue this case until the May 11th hearing. That way I'll give you guys time to look and see what happened. And perhaps you can even work that out with the city, and maybe I won't see you again.
Okay.
If not,
Should
I
we
will
call
see you.
Or
You can.
if you want, if we have the information, I'll provide it.
Yep.
Yeah.
And so I'll just get you in order, make sure I have your contact information, and then we'll set a status hearing for May 11th.
Thank you.
All right.
All right, thank you, Your Honor.
Thank you.
Thank you. Okay, moving on to case 4G, case number 202602125, City of St. Pete Beach versus LVD Homes LLC.
Thank you, Madam Magistrate. Stephen Rivera, City of St. Pete Beach Code Enforcement. Case number 202602125. Respondent is LVD Homes LLC. Violation address is 2962 East Vina Del Mar Boulevard. Violation description: the property is in violation of Section 8.2, permitted uses and structures of the Land Development Code of the City of St. Pete Beach. Case summary: initial inspection was 2/27/2026. Irreparable or irreversible notice of violation dated and mailed certified 3/12/2026. Notice of hearing dated and posted to the property 3/12/2026. The following is a true and accurate representation of what I've witnessed. This is the affidavit of posting, 2962 East Vina Del Mar Boulevard. This is the Airbnb advertisement. This is the host information. Property had one stay, says stayed about a week. Property's only permitted to have monthly stays as well. It's the Airbnb review policy. Corrective action: the property can only be rented monthly. The property is compliant. Recommended fine is $1,000 per violation for the one review, plus a $330 administrative cost and any recording fees that may be associated with the property. I did speak to, well, there was a note, our admin did speak with the property owner. She realized that she couldn't do it. She did take the ad down. I'm sorry, she did stop the short-term rentals, from what I understand, a couple days before we posted the property. However, the case was already open, so we had already decided to bring the property in for the I&I.
Okay. Anyone here on behalf of LVD Homes LLC? Okay. All right, seeing no one, I will go ahead and find that the property is in violation of the stated code sections. It is irreversible, irreparable. We'll go ahead and assess the $1,000 for the short-term stay plus the $330 in reasonable administrative costs of the city and any recording costs that are there so related.
Thank you.
Moving on to 4H, case number 202600096, City of St. Pete Beach versus Michelle Crook and Jamie Crook.
Lucy Knight, case number 202-60046. Respondent Robert Pardo, violation 3593 Bell Vista Drive, violations.
Ms. Knight, I think we're on the Michelle Crook and Jamie Crook case before the Pardo case.
That's the next one.
Well, 4H is the Crook case that's continued to May.
Yeah,
Did
I was going to ask, can that one be continued to May 11th?
Okay. Anyone here on behalf of the Crooks?
No, they're not here.
I will go ahead and grant a continuance then till the May 11th hearing.
Thank you.
Okay, then moving on to 4I, case number 202600046, City of St. Pete Beach versus Robert Pardo.
Lucy Knight, code enforcement case 2026046. Respondent Robert E. Pardo, violation address 3593 Bell Vista Drive. Violations description: The property is in violation of Section 4633, enumeration 1A, B, 2, 3, 13, Section 9865, unsightly condition, 1A, B, C, 2, 4, 6, Section 9866, resident and commercial property maintenance, AB 20, 22, A, E of the Beach Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspection was on 1/27/26. Notice of violation dated and mail certified 2/27/26. Notice of hearing dated and posted on the property 3/19/26. Affidavit of posting. This picture is true and accurate representation of what I observed on the date it was taken. The fence is in disrepair. The weeds and the grass, debris in the palm tree, debris on the side of the house. Property must repair fence and remove debris. Property is not in compliance. Recommended fine is $250 per day from the date of your order, plus $330 administrative costs and any recording fees that may be associated with this case.
Okay, thank you, Ms. Knight. There are a couple of citation or sections that were cited that I didn't see any evidence of. That one was subsection 13 on 4633, which is the storage of any vehicles or motorized or non-motorized vehicles. Was there anything on the property that was?
That's the next case.
I'm on Robert Pardo. That's the case that we're on.
Oh, yeah, I don't have that on.
Go back to the slide, the violation sections, please.
Subsection 13 says the storage of vehicles, whether motorized or non-motorized.
Oh, it's a
313.
It's a trailer on the property.
Can you show me the
Yes,
evidence
ma'am.
of that, or?
It's in the corner right there, I'm sorry. Can't see it that well.
At all?
Yeah, it's a green on the right-hand side. It's a trailer that's been parked there for a moment.
Okay. And then you've also cited for trees, hazardous or dead or dying trees. I see that there in that picture.
Yes, ma'am.
And then outdoor storage, is that?
It's a boat, oh my goodness. It's a boat on the side and then
The orange
blue
boat,
tarp,
okay.
yes.
Okay, thank you very much. All right, is there anyone here on behalf of Mr. Pardo? Mr. Pardo, can you please come up and let me know what's going on with the property?
Can you swear me in or anything?
Have you not been sworn in?
And that was the first thing I was gonna do, approaching y'all. I apologize for being moments late. I just got off the phone meeting with my employer out of New York, so.
No worries, go ahead and raise your right hand.
Okay.
Do you swear from the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Perfect. Okay, Mr. Pardo, go ahead.
Great, thank you. And I would, and just to take the proper channels, given what Mr. Myers earlier this morning had mentioned, I'd like to just share, I know my hands are full, but if he needs assistance in any kind of way, I just want to offer my contact number for him.
Very much.
Pardon me?
Your information on this paper.
No, if you can give it to Mr. Rivera. And
Oh, okay, there we go.
Thanks, sir.
You're welcome. Thanks for allowing me to speak. It's just been, since the hurricanes, it's been just a lot of things that have taken place. About 2 weeks before Helene, we lost my dad, and him and mom were living in Venice. And so since then, she's had a mini stroke. Go down there quite often. So I would suggest that's been an obstacle as well. The funds from the insurance claims have been tied up over TD Bank. And, as the claims come in, the endorsement is required, but yes, by me, but also by the bank. We had an inspection done. It came in at 52% that the bank sent in the inspector. Things are coming together, but I'm still not, really, I haven't passed the inspections here by City of St. Pete Beach. My understanding is the electrical now needs to be taken care of. Plumbing passed. And then the trailer that she was kind enough to share, there was a trailer there, just living there. And so since the time came to an end through FEMA of me staying in whatever other accommodations, I've been living there at the in the trailer and showering in the house and preparing myself for the day, for work day. I would like to add that I have retained, as of more than a week ago, a couple of weeks ago, well, let me preface that a little bit with the certification or certified mail. I had been calling that phone number that's on the item that's certified mail, and there's no answer. I didn't know what it was, I guess. So I just wanted to have you all recognize that the, I guess, February 27th date, I didn't get that piece for weeks later. Just want to share that. I did retain the services of York Landscapes. So there has been, I would suggest, improvements on the property quite a bit. But York Landscapes, and his name is Jason York out of Gulfport. He has been to the property in the last, actually he was at the property maybe 2-3 months ago, but I'm trying to deal with the bank and getting funds, as well as my contractor's still not finished, and there's equipment there still at the maintaining at the house. But I have retained Jason York to work on the house. He came by not yesterday, on Friday, do some measurements. He's got a plan. I think he's going to do the heavy work. This week is when he's going to start. I had mentioned maybe a bobcat that he was going to work with. He actually said, no, I'm going to use a dingo. So I think a dingo is larger than a bobcat. I'm really not too sure. But it's just a lot of work, and shame on me. But I take this as a learning experience. But I would like to ask for leniency of whatever you would offer in days. But I think it's going to be geared up, and I've got to get back in touch with TD Bank. I actually sent them an email on Saturday morning, because I work for a bank, for Citibank, and I have quite a bit of banking experience. They're just not following the guidelines that I see. But when I'm working for the bank 5 days a week, Monday through Friday, I'm not allowed to send emails or anything like that on the bank portal. You'll probably understand. Try to use my phone, but it's not so smart. It's a smartphone, but it's not so smart. And let's see, what else can I share to you? I did have a property. There's been a water leak on the property that's been there for years. And the workers come out there about every 2 years to repair it, so it's never repaired 100%. I did notify the city. They sent someone out there, at least they got in touch with the county, and they came to repair it. So I just want to go ahead and share to you all that the grass was really, really overwhelmed in an area, because that's where that water kept leaking. So to try and maintain the property, that was challenging. I did do a lot of the digging up of the trees. They're gone, except for one that I just brought down, the one that was tilted. That's now down, and Jason's going to haul that away. I did get a sickle to try and cut the grass with, so it's maintained a lot more, but I just got that sickle off of, I don't know if you all are familiar with a sickle. But I got that on Amazon. I said, let's get cracking. So I've just been busting my backside, but going down to Venice to take care of Mom whenever I can.
So then, Mr. Pardo, you said you just needed some time. You've got Mr. York who's kind of coming in and helping you out. How much time do you think it would take to get the property, not the interior, I understand with the trailer, but the exterior as far as the overgrown vegetation cleared out?
I'm hoping, but as you all probably have experienced by others, you kind of hope that it's going to be done in 30 days. I didn't think I'd still wouldn't have, have my inspections passed already with all the time that's gone by. I would suggest 30 days. Hoping if he gets there with the dingo this week or next week, let's get this thing done. So that I'd like to look at 30 days within that time frame.
Okay. All right. Well, then, anything else that you would like me to know? Relevant to this property.
No, I can understand. No, not that I can think of. I just jotted down some notes, and I wanted to let you know I do have dates of emails and things of that nature, or text messages, so I can offer that to you all if you'd like to have that, but I have just made noteworthy.
I appreciate that. You said the trailer that's on the property, you are living in that currently until such time as you can get the permits for the interior of the home. Is that correct?
Well, the passing of the inspections.
Okay.
Yeah. And I've just been sleeping in there, but then I've been just staying, the showers I can use in the house, that kind of thing. And not to say all the showers are complete and done. I still have my contractor, who I'll give a low grade to. He's not here to defend himself on that, but yeah, it's just been a crazy experience. I'm sure I'm not the only one, but that's how, this was my first rodeo with hurricanes. I was raised in Oklahoma. Tornadoes I can deal with. Hurricanes, it's just a different flavor.
Yep. Okay. Okay, great. Then I will allow for 30 days to bring the property into compliance, and then we will meet back here at the June 8th hearing if, 30 days, yeah.
Okay, great.
If we need to. Hopefully the property will be cleaned up by then.
Okay.
If not, we'll have a status hearing, and then I can determine if the property is in compliance or if we need to assess any fines at that time.
I too appreciate that. Thank you. There's,
Yes.
Could we amend that notice to read 21 days and a status update May 11th as a show of good faith from the property owner? We understand his circumstances, but this has been weeks in the making. And it affects the neighboring properties.
Okay. I mean, do you think you could get it done in 21 days?
so we're looking at May 11th?
And May 11th coming back?
Yeah, and when you say get it done, do you want just open communication? I've already emailed the city manager and Joanne Boland here at the city, just kind of let them know what's been going on in the last few weeks.
If you could also go ahead and loop in a code enforcement with that as well, so that they know what's going on.
Yeah.
As far as, so that way they can be kept apprised. I know it's the city, but sometimes one hand doesn't know what the other hand is.
I understand.
what information they have.
So communication by May 11th? Is that what you'd like, or to have it completed?
21 days for compliance, so to clear the property. And then we'll have a status hearing on May 11th.
Okay. That sounds great, thank you.
It wasn't raised, but I have a question, maybe Ms. Suprick's the right one to ask on this. There is, or was, and I know the emergency orders are still being extended. The trailer on the property, if he is living in it as a result of hurricane damage, is that something?
I will have to look into that. I know in other jurisdictions, they have local prohibitions, probably in the zoning code as well. I think our building official knows the answer.
Probably should have addressed my comments to Mr. Curtis.
Oh, forgive me.
So our city code does prohibit living in a trailer or a motorhome, but post-storm, we did approve the use of a temporary living accommodations for those trailers and RVs. So with an application that's sent in, it can be approved. It's merely just to document that, hey, somebody's living in here during the repairs. So it's perfectly acceptable for this scenario.
Okay.
So they did that purposely to help accommodate property
So that's
owners.
something Mr. Pardo could do if he needs to continue to have that trailer on the property while undergoing repairs in his home.
Yep, for temporary occupancy.
Okay, great.
So I'm going to suggest, I'm finding that there's a violation, you have 21 days to clear the property and remove the trailer, but if you get application to the city and you're allowed to have that there, then the trailer can stay.
Okay, outstanding, thank you. And I did have another question, if you don't mind, because I don't know what Jason York's landscaper, what he has in mind, but if he's going to clear out, he's actually going to tear out all the grass and weeds and everything out of there. I'm looking at crushed shell, for instance. It'll be cleared out, I envision, but I don't know what he's going to have as working equipment there or something like that.
You're going to need to get with the city and stay in communication with code enforcement to see if that's okay during
Okay.
that time, so that you are, one, found to be in compliance by that date, or two, that you're not in violation of something else.
Okay, yeah, that sounds great.
And I will get you in order, just make sure I have your contact information, and it will detail all those dates and information in it.
Okay, and one last item, I hope you don't mind. I heard something about relocation of a trailer with another individual here. Can I relocate with the trailer I'm staying in, if it's collapsed, it's a Coleman, can I relocate it onto the other side of the property?
I don't know about that. You're going to have to get with the city on that and see if that's.
I'll take care of
If it's
it.
on the property, it's on the property, it's on the property. You can't be living in it unless you have approval to do so.
Okay, I'll check it out. I'll take care of it.
Okay, thank you, Mr. Pardo.
Thanks very much, y'all. Thank you.
And we are at
J.
or J. Case number 202601119, City of St. Pete Beach versus Ty Jacob Leaf.
Tonight, case number 202601119, Ty Jacob Leaf, 4111 Miller Drive, violation description. The property is in violation of section 46-33, enumeration 2313, section 98-66, residential and commercial property maintenance. A 2024E, section 9867, junk vehicle, junk vessels, and abandoned property, E. And section 99-6, maintenance requirement, A of the Code of Ordinance of St. Pete Beach. Case summary, initial inspection 2/27/26. Notice of violation dated and mailed certified 3/13/26. Notice of hearing dated and posted on the property 3/31/26. Affidavit of posting. This picture is true and accurate representation of what I seen on that date. The fence in disrepair. The other side, both sides was disrepair. The weeds in the grass, the construction materials, unregistered trailer tag, debris in the yard. Property must repair fence, remove construction blocks, weeds, debris, and have tag registered. Property is not in compliant. Recommended fine is $250 per day from the date of your order plus $330 administrative costs and recording fees that may be associated with this case. I went by it this morning. Did you let this bring up? And it is now in compliance. That's the gate on the left-hand side, and the trailer and the construction material is going now. Just asking for admin fees of $330.
Okay. Is anyone here on behalf of the property owner, Mr. Leaf? Anyone here on behalf of Mr. Leaf? Okay, seeing none, I'm going to find that the property was in violation of stated code sections, however, is now compliant. I'm not going to associate any fines with the property, but I am going to assess the $330 in reasonable administrative costs of the city.
Thank you.
We have continued 5A. We have handled 5B. There is nothing under agenda item 6. Agenda item 7, nuisance abatement cases. A, case number 2026080, City of St. Pete Beach versus 5411 Palliway Land Trust, and it's trustee Christopher McMillan.
Lucy Knight, case 20260080, respondent, Land Trust, McMillan, Christopher Trust, trustee, violation address 5411 Pally Way, violation description. The property is in violation of section 46-142, A4 and B4, pattern of nuisance activity of the chronic nuisance property code for the city of St. Pete Beach. Final order imposing fines and costs was case number 20250056 on 7/14/25. Violation of sections 46-33, enumeration, 98-64, general maintenance, 98-65, unsightly conditions, and 98-66, residential and commercial property maintenance. Case summary, initial inspection was 1/15/25. Notice of nuisance dated and mailed certified 3/9/26. Notice of hearing dated and posted on the property 3/9/26. Affidavit of posting, this picture is true and accurate representation of what I seen on that day. Recorded lien on December 9th, 2025. This is the second half of it. I couldn't fit all on one page. St. Pete Beach unsafe structure, 2/10/26, that was posted. Nuisance inspection, where the pool is unsafe and the screen enclosure have fallen in. Same picture. This is another nuisance inspection of the bay window where it's cracked at the bottom. Nuisance inspection. This is a further distance from the pool. This is on the side of the house where all the debris is. This is the opposite side of the house. The window is all broken out. This is on the back patio. This is a side gate that's missing. Property is not compliant, section 46-143B. No written action plan provided. City would like to board up the property for safety reasons, environment conditions, health hazards. Recommended billing costs of services to abate the nuisance, plus $330 administrative costs and any lien recording fees that may be associated with this case.
Thank you. Is anyone here on behalf of 5411 Pally Way? Anyone here on behalf of 5411 Pally Way? I know there's nobody here, but I have to say it for the record.
It's okay.
Ms. Knight, have you had any conversations with the property owner or any of the representatives?
No, ma'am.
And I do understand that the city's chronic nuisance abatement definition of pattern of nuisance activity. Nuisance activity means any activities related to the following violations whenever engaged by the property owner, agent, tenant, or invitee. The one that is cited is junked, wrecked, abandoned property as defined in Chapter 46 of the code. Which is a little cyclical, but this talks about determination of abandoned or unclaimed property. So either Ms. Knight or Ms. Stuparick, can you explain to me that specific section of the code? I see the pattern of nuisance activity is defined as just not complying with a code enforcement order. I don't particularly have an issue with that. But what I see here is an unsafe structure, which there's evidence of saying. I don't see that there is a single code violation for failing to bring the property in compliance. The reason I'm asking is chronic nuisance abatement is quite heavily litigated. And I don't see that it fits within the definition. It's not been multiple times of coming up with the debris on the property or something that's happened. It is definitely an unsafe building, but I don't know that I would qualify this as a chronic nuisance as per your code. So again, because your code defines junked property as abandoned or unclaimed property.
You also mentioned not adhering to the order.
Yeah.
There are two separate things. First, you have to have a nuisance activity, right? And then you have to have a pattern of nuisance activity. You lack the nuisance activity as it's been cited. The pattern of nuisance activity is failure to comply with the order. I don't have a problem with the pattern part. The issue that I have a problem with, and I don't have a problem with it, I just need some more clarification as to, it's been cited under 46-142A4 as as what the chronic nuisance is, which is junked, wrecked, abandoned property as defined in Chapter 46. But when I look at what that definition is, it looks like it's abandoned property. So are we saying that the property itself is abandoned?
We could, because of the fact that there really hasn't been any remedial activity since the date of your last order. And
Do we know, is anyone living in the house? Has it been abandoned? Is someone paying the taxes on it? Is somebody paying the mortgage on it?
So perhaps some testimony to that effect.
I don't know if this helps to clarify. I have visited the site. Pardon me. I have visited the site, and it appears as though nothing has been done with the property since the storm hit. There's literally clothing and personal belongings that are throughout the house. It's not fit for habitation, but there's no appearance of anybody inhabiting the house, but it appears as though it would have day one after the storms, so nothing has been done there.
And nobody's had any communication with the property owner at all?
No, ma'am.
As Mr. Curtis mentioned, the I as well visited the property. The property appears to be vacant. There has been no communication, there's been no contact, but from all appearances, it does appear that the property has been left the way it is currently since the storm.
Problem is, underneath Article 3 of Chapter 46, junk wrecked or abandoned property, which is what your cited section relies on, it talks about personal property. It does not talk about real property. Perhaps there is another section that can be cited under. But what I see here is you have cited the property owner in violation of 46-142A4.
Madam Special Magistrate,
Yes.
excuse me, could we please continue this case?
We recognize the difficulty.
There may be a different code
Yes.
section you can cite under, but if the city is going to proceed under this, I don't see
We
it.
would,
because it's
we
not-
would like to ask for a continuance so we can take a closer look at it, and if we have cited the incorrect section, we'll bring it back correctly.
Okay, so I will go ahead and continue this case until the May 11th hearing.
Yes, please.
Thank you.
Thank you.
Moving on to 7B, case number 202-50069, City of St. Pete Beach versus Annie Nguyen and Jimmy Trong.
Sayaka Ruktashel, City of St. Pete Beach Code Enforcement. This case is going to be similar in nature. Case number 202-50069, the respondent Annie Nguyen and Jimmy Trung. Violation address 205 55th Avenue. Violation description of the property is in violation of sections 46-142A, 4, and B4, pattern of nuisance activity of the chronic nuisance property code for the City of St. Pete Beach.
Mr. Ruktashel, excuse us. We're contemplating this could be the same situation as the previous.
It is
So,
same
please
situation.
ask for a continuance.
Okay.
Thank you.
With this same situation, could I ask for continuance to the next special magistrate?
Continue this to the May 11th.
Okay. Thank you.
All right, moving on to lien reductions 8A, case number 202-50711, City of St. Pete Beach versus Brendan Doyle and Courtney Doyle.
How you doing, Madam Magistrate? Steve Rivera, City of St. Pete Beach, Code Enforcement. Before we even get into this, I had a gentleman stop me in the hallway, I guess was coming to represent this. He did not have power of attorney and decided to leave. So I don't know if we should go.
It's his application, it's not the city's application.
Well, yeah, and he's not any of the property owners. I asked him if he was the property owner. He said, no, I'm just a neighbor trying to help out, but he didn't have any power of attorney, POA, to speak, so he left.
And
So-
this is a petition, not,
Yeah.
it's not coming from the city, it's coming from the property owners. Since the property owners aren't here, I'm just gonna deny it. I mean, there's no one here on behalf of them.
Yeah.
So,
Okay.
there's no one here to petition it, it's denied.
Thank you.
Moving on to 8B, case number 202-50712, City of St. Pete Beach versus Team B Equities. Before we begin, is there anyone here on behalf of Team B Equities? Seeing none?
No.
Have you had any conversations with them?
No, and in fact, they've just gone ahead and paid the lien, so they were not even a request.
So I'm not even gonna, that's withdrawn then. I'm not gonna
Right.
consider that one. All right. All right, the next hearing is set for May 11th at 10 a.m. We are adjourned. Wait, before we are adjourned, is there anything else that the city needs to discuss while we're on the record?
No, Your Honor. Thank you for your endurance today, because we had quite a long agenda. We appreciate it.
Of course. Well, thank you very much. We are adjourned. All right.
Thank you.